All right, so we're on the record in docket 2503223. That is People of the State of Michigan versus Jeffrey Barnes. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Nickel.
Good morning, Your Honor. Tara Nick on behalf of Mr. Barnes, who's to my right at council table.
And sir, you are Jeffrey Michael Barnes, is that correct?
Yes, Judge.
Thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people are prepared to unconditionally waive the preliminary examination. It's my understanding that the defendant is prepared to do the same.
And negotiations are continuing.
Yes, Your Honor. Negotiations would continue in circuit court.
And is that a fair statement, Ms. Nickel?
Yes, Your Honor.
All right, may I inquire of your client his waiver of the preliminary examination?
Yes, Your Honor.
Mr. Barnes, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by the Public Defender's Office.
No, I'm on my own, Your Honor.
Oh, you're on your own?
Yes.
Okay. So you are represented today by attorney, it's Tara, right?
Yes.
Tara Nickel, and she would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to a preliminary examination, have this case continue in circuit court where negotiations are continuing. Is it your wish today to waive your right to a preliminary examination?
Yes, Judge.
Do people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made, and I will provide the documentation, find over documentation to sign.
Thank you.
All right, I'm in possession of the bind over documentation on docket 2502422. I'll indicate that the examination has been waived on today's date. And bond is set as 3,500, 10%. It's been posted. Anything else before I sign the bind over documentation at Ms. Fortuna Gill?
Not for the people.
Ms. Nickel.
Not from the defense. Thank you,
All
Your
right.
Honor.
I will sign this here. So, sir, Mr. Barnes, your time in district court is done. You're off to circuit court, where you'll get your next date. You'll get your next notice to appear from your attorney, Ms. Nickel. All right.
Okay.
All right. You're all set. Thank you for your appearance today.
Thank you.
We are ready on Cochran. And then we're also ready on Lance Gailey. If you want to bring him up, Megan, we can do that as soon as he gets up.
So we'll go get Gailey and let's do Cochran, and then I might, depending on what we're doing on Cochran. So we're on the record in docket 2503164. That is People of the State of Michigan versus Charles Lee Cochran. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender for Mr. Cochran.
And sir, you are Charles Lee Cochran, is that correct?
Cochran, but yeah.
Cochran, thank you. You're all set for, this is time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people do not have the necessary witnesses ready to proceed. They were subpoenaed. My office has had contact, but this does not come as a surprise to me.
Okay,
You make a motion to dismiss, Judge.
all right. So the people are unable to proceed. The complaining victims were subpoenaed. There's been some contact with complaining victims, but it's not, today they're not here.
That is correct, Your Honor. And I'm of the belief that if we did have an adjournment, they wouldn't be here then
Right.
either.
All right. I will, I'm gonna draft Miss Robinson to pull a nollie pros from the, is it printing it?
Yep.
Thank you, Miss Robinson.
No problem.
All right, so I'm in possession of the nollie pros on 2503-164. Mr. Cochran, this means the case is going to be dismissed without prejudice. The people could reissue if they choose to, because they're unable to proceed today. Realistically, based on the prosecutor's comments, I don't think it'll be I don't think it'll be reissued, but that could happen. All right. All right. I'm going to sign at the defendant's request. I'm going to sign the motion for dismissal. Without prejudice. And there is a no contact order, so you should keep an order of this, and you because for my court officers bringing somebody up, but you should keep a copy for your records. It takes about 4 hours to purge from the computer system. So
Oh, the no contact.
yeah, the no contact order.
Okay.
So
I'm not
so-
too worried. I don't plan on talking.
All right,
about it the next
all
couple
right.
hours, so.
so you understand that it takes about 4 hours. Okay. Anything else for the record in 2503-164, Ms. Fortuna Gill?
Not for the people.
Ms. Robinson.
No, Your Honor, thank you.
All right, Mr. Cochran, good luck to you.
Thank you.
Is that Mr. John? Oh, okay. Sure. Understood. Sure,
Thank you. I'm not trying to come.
you're okay. Your Honor, if we could handle, Robert Stutz, I know that's a little bit later in the morning.
Sure.
But that's gonna be a waiver. I think we get that
All
done
right.
before Megan gets back.
Mr. Sutz. All right, we're on the record in docket 2503-217. That is the people of the state of Michigan versus Robert Sutz. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Mr. Stutz, who stands to my right.
And sir, you are Robert Charles Sutz, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people are prepared to unconditionally waive the preliminary examination. It's my understanding the defendant is prepared to do the same.
Is that a fair statement, Mr. Palmer?
Yes, Your Honor, that's accurate. My client already has one matter pending at the 30th Circuit Court. We're going to waive and head to that court where we'll seek global resolution.
All right, so negotiations are continue. There may be global resolution as part of what was placed on the record. Mr. Palmer, may I inquire of your client of his waiver of the preliminary examination?
Of course.
Mr. Sutz, you understand you have the right to a preliminary examination day. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You were represented today by attorney Robert Palmer, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to preliminary examination, have this case continue to circuit court where negotiations are going to continue.
Yes,
Is
Your
it
Honor.
your wish today to waive your right to preliminary examination?
Yes, Your Honor.
Ms. Fortuna Gill, did the people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver to be knowing, voluntarily, and accurately made. And I will provide the documentation for signature.
Sure.
Yeah. Okay.
All right. Thank you. So I'm in possession of the bind over documentation on 2503-217. I'm going to indicate the examination's been waived on today's date, which is December 5th, 2025. Bond is set at PR bond. Anything else before I sign the documentation from the people, Ms. Fortuna Gill?
No, Your Honor.
Mr. Palmer?
No, Your Honor, thank you.
All right, Mr. Sutz, you're off to, your time in district court is done. You're off to circuit court. Will you get your next notice to appear from your attorney, Mr. Palmer? All right, sir?
Thank you, Your Honor.
Thank you.
Good day.
Everybody on landscape.
Mr. Gailey. That's Ms. Schroeder.
Yes, Your Honor. And this is going to be a waiver, so if the paperwork here.
All right, so we're on the record in docket 2502-061. That is people of the state of Michigan versus Lance Michael Gailey. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Mr. Gailey. Mr. Gailey as present stands to my right.
And sir, you are Lance Michael Gailey, is that correct?
Sir.
All right, thank you. This time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people are prepared to unconditionally waive the preliminary examination. It's my understanding that the defendant is prepared to do the same.
Is that a fair statement, Ms. Schroeder?
It is, Your Honor.
And I'm assuming negotiations are going to continue.
That is correct.
Yes, Your Honor.
All right, Ms. Schroeder may inquire of your client of his waiver of the preliminary examination.
You may, Your Honor.
Mr. Gailey, you understand you have a right to preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Aaron Schroeder. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have the case continue to circuit court where negotiations are going to continue. Is it your wish today to waive your right to a preliminary examination?
Please and thank you, Your
All right.
Honor.
Ms. Fortuna Gill, do the people also waive their right to a preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made, and I will provide the bind over documentation for signature.
Okay, so it's silence like that.
Ms. Fortuna, did you want Megan to get anybody else? Well,
Yeah, she could get Mr. Johnson. The Wilcox exam is going to run. So,
okay.
but Mr. Johnson's matters aren't running,
Alright.
so that should be quick. Thank you, Megan.
All right, so we're on the record, back on the record at 2502-061. I'm in possession of the bind over documentation signed by all the parties. I will indicate that the examination has been waived on today's date. That'll be 12/5/2025. And bond is set at $1,000 at 10%. Anything else for the record in docket 2502-061, Ms. Fortuna Gill?
Not for the people.
Ms. Schroeder,
Thank you, Your Honor. If I could be heard as to bond.
you may.
Thank you. Mr. Gailey has been in custody consistently since July. I have an arrest date of July 10th, 2025 in our system. That gives him, it's my understanding, of 149 days in. I do understand I understand that these are serious allegations against him. However, he has been in for quite a long time. And we don't know when he will be assigned a circuit court judge, and that can take several weeks. I'd ask the court to consider him for a PR bond, as even though it is a 10% bond, he's clearly not been able to post it. I mean, $100 he doesn't even have to his name. So right now, I would argue he's literally staying in custody because he is indigent in the truest sense. So if the court would consider a PR bond, he has an uncle he is very concerned about, whom he does reside with, who has health issues, and he is very concerned about him. Thank you.
All right, thank you, Ms. Schroeder. Ms. Fortuna Gill, response.
The people have no position on bond, Your Honor.
There is only one thing concerning bond to me. These aren't assaultive crimes. The MDOP is a misdemeanor, and the home invasion third is not a first or second. So I'm not concerned about that. I am a little concerned about the previous felonious assault, because that is an assaultive crime that is part of the history. But Mr. Gailey has definitely been incarcerated for, but we started this arraignment in July, and then it looks like as of July 1st, that would be my guess. The order came out July 17th. Based on the current history of the home invasion third and the misdemeanor MDOP, does Mr. Gailey have a place that he can stay?
That's still the Shiawassee.
Yes, ma'am.
That would be 723 Shiawassee Street, apartment 8. I believe
That's the last address we have after arraignment. Is there any, just to update, is there any phone number? And we have a phone number, but I don't know if that's the same phone number.
It's 517-216-8125, because I do share my contract and my cell phone with my uncle.
All right, and that's the number we have.
And that's the number we have as well,
Okay.
Your Honor.
All right, I'm gonna set bond in this matter at a PR bond for 50, so it'll be $1,000 PR. And I will sign the documentation, but I'll change the bond amount to $1,000 PR. I'm gonna sign the bond documentation. So your time in district court is done. You'll be off to circuit court. You'll get your next notice to appear from Ms. Schroeder, your attorney. All right, sir?
Yes, sir.
All right. Anything else for the record in 25-02061, Ms. Fortuna Gill?
Not for the people.
Ms. Schroeder?
Not for the defense. I'm just going to make sure Mr. Gailey has my card here, but nothing
Okay.
further. Thank you.
All right. You're all set, Mr. Gailey. Thank you for your appearance.
Judge, I don't
Thank
see
you, Your
Mr.
Honor.
Sartz in here. Do you want me to still bring his client? Oh. look at that. He's just here, but that's a great question.
That's a great question.
Because
Because I saw, but
He was
this,
here, yeah, but he's not anymore.
Yeah.
So I don't want to bring his guy up if he's not.
Right.
To be candid.
yeah, I don't know where Mr. Sartz is, but
If that's the case, then. we
Mr.
could
Sartz
bring
could
up-
be in another prelim, so.
Sure, we could bring up Miss Wilcox and that, I mean, that exam is going to run, but I don't anticipate it will be very long.
All right, let's bring up Wilcox. Because I saw Mr. Cornish is here,
Yes.
and then,
We are ready on Thomas.
Monet Thomas?
Yes.
Mr.
That's bad
Sartz,
luck for
you
you.
missed us by about a
Not even
minute.
2 minutes.
I texted you. Corners to do ours.
All right, this is Miss Thomas. Monet Thomas?
Yeah. Are you here for?
All right, so we're on the record in docket 25-03414. That is people of the state of Michigan versus Latrice Thomas. Appearances for the record, Ms. Fortuna Gill,
Haley Fortuna Gill on behalf of the people.
Ms. Robinson.
Erin Robinson, Assistant Public Defender on behalf of Ms. Thomas.
All right, this is the time set for a preliminary examination. It was set for 8:30. It is now 9:52. I don't see Ms. Thomas with the attorney of record. There's nobody in the Zoom courtroom. Is there anybody in the physical courtroom by either for Ms. Thomas or represents Ms. Thomas?
Well, I
other than Ms.
represent Ms.
Robinson?
Thomas.
Yeah, yeah.
But no, I don't see Miss Thomas here.
Have you had any contact with Ms. Thomas?
I've not.
All right. How did you want to proceed, Ms. Fortuna Gill?
Your Honor, at this point, the people would be requesting a bench warrant due to assault and battery being one of the alleged crimes. The people would be requesting that a bench warrant be immediate.
All right, Ms. Robinson, any comment on that?
We would just ask for a 48-hour hold.
Based on the prior assault and battery, I'm going to issue an immediate bench warrant. But if you let us know, we'll arraign her as soon as
Thank you,
we
Judge.
can. So immediate bench warrant based on the assault and battery. Anything else for the record in 25-03414, Ms. Fortuna Gill?
Not for the people.
Ms. Robinson.
No, Your Honor.
All right, thank you for your appearance today.
And while we have Ms. Robinson, if we could call Jacob Jarvis.
Charis. 25. All right. All right, so we're on the record in docket 25-03404. That is people of the state of Michigan versus Jacob Jarvis. Appearances for the record of Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Robinson.
Aaron Robinson, Assistant Public Defender for Mr. Jarvis.
And sir, you are Jacob Jarvis, is that correct?
Jacob Jarus, Your Honor.
Jarus, thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people do not have the necessary witnesses required to proceed. My office has been unable to get contact with the complaining witness despite several attempts, and they were subpoenaed. So at this point, we anticipate a motion from defense counsel.
Ms. Robinson.
We would make the motion to dismiss, Judge.
All right. So based on the prosecutors, the people of the state of Michigan's indication that they're unable to proceed, the complaining victim was subpoenaed and did not appear. And any contact to get them here has been unsuccessful. We'll grant the motion to dismiss without prejudice. Thank you, Ms. Robbins. All right, so I'm in possession of the order of acquittal or nolle pros on 25-03404. Based on the defendant's motion and the representations of counsel, we're going to dismiss without prejudice. This means, Mr. Jarus, that this is dismissed without prejudice. The people could reissue if they choose to, but realistically today the case is dismissed. There is a no contact order. So if you choose to, it takes about 4 hours to purge from the system. So you can get a copy of the dismissal if you choose to. I think the court officer is taking somebody down. But if you choose to, we can give you a copy of this to keep on your person for the rest of the day. All right, sir?
Thank you, Your Honor.
Anything else for the record in 25-03404, Ms. Fortuna Gill?
Not for the people.
Ms. Robinson?
No, Your Honor, thank you.
You're all set, Mr. Drews. Thank you.
Thank you.
Mr. Maki is going to be a plea. We're ready on that. Yeah, he will do it.
All right. All right, so we're on the record in docket 25-02982. That is people of the state of Michigan versus James Mackey. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Patrick.
Good morning, Your Honor. Melissa Patrick on behalf of James Mackey, who is here to my right.
And sir, you are James Dean Mackey, is that correct? Thank you. This is the time set for preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, a plea offer has been extended. It's my understanding the defendant wishes to avail himself of that offer. The offer being to plea to sorry, Tammy. A fleeing and elude fourth degree.
Okay, so we'll add that as so that's count one.
Or is that
An
actually
attempt.
count?
So it's
An
attempt.
attempt. It's an
Okay.
attempt. Your
So we'll
Honor.
add that as count three. Add count three of attempt, flee and elude in the fourth degree.
Yes. It would be a dismissal of the remainder
Okay. So,
and an agreement to no upfront jail.
all right, and is it the same PAC code except with an A after it?
Yes.
So it's 257.602A.
So it would become a 1 year.
And it's a 1 year and or $250.
Yes.
All right, and then on successful plea and sentence counts 2 and 3 are to be dismissed.
Or it's an added count 3, so it would be counts 1 and 2.
1 and 2.
Okay.
Perfect.
And the habitual offender.
Yes. Oh. Yeah. So.
And then the habitual offender.
Yeah.
And there's a Killebrew agreement of no upfront jail.
That's correct, Your Honor.
Right.
All right, so Mr. Mackey, my understanding of the plea offer, and you can confirm this with Ms. Patrick, is an added count 3 of attempt flee and elude fourth, that is punishable by 1 year and or $250 pursuant to 257.602A2A. There's a Killebrew agreement between counsel, the people of the state of Michigan, and your defense counsel. They received no upfront jail on this. And counts 1 and 2 are going to be dismissed upon successful plea and sentencing along with the habitual offender. Is that your understanding, sir? Okay. All right, and that's your understanding, Ms. Fortuna Grill. I've just indicated that.
Yes, Your Honor. It has come to my attention that we should change the MCL to the 750 flee and elude to ensure that the penalty is 1 year as opposed to 2.
All right, so yeah, they're both, I think they're both, but one is under one. So that would be
750.479A. Yes.
That takes it out of the motor vehicle code.
Yes.
Yes, all right. All right, is your understanding, Ms. Patrick?
Yes, Your Honor.
All right. All right, Ms. Patrick, may I inquire of Mr. Mackey of his misdemeanor advice of rights?
Yes, Your Honor.
All right. Mr. Mack, you understand the ultimate penalty for this sentence is 1 year and or $250. There's an agreement between Ms. Patrick and Ms. Fortuna Gill. They received no upfront jail on this. If I was going to do anything different, you'd have the opportunity to withdraw your plea. Do you understand that, sir? Okay. So you have the following misdemeanor rights in this case, and I'm going to walk you through each of your misdemeanor rights. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Melissa Patrick. She would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Sure.
You have the right to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you in the testified trial if you choose to testify. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we placed on the record, or threats that it was not your choice to plead guilty. You'll also be giving up the right to appeal anything from trial. Since you won't be having a trial, you'll be pleading to the misdemeanor instead. Is it still your wish today to waive your jury trial rights and plead guilty to the misdemeanor?
Yes, sir.
I'm gonna have you raise your right hand as best you can. Do you solemnly swear or affirm, tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I am going to bring your attention back to September 30th, 2025, at the offense location of Mount Hope Mount Hope on Pennsylvania Avenue in the city of Lansing. Were you operating a motor vehicle open to the general public on that September 30th, 2025?
Yes, sir.
All right. And at that time, what did you do in regards to attempting to flee and elude fourth degree? I have here that you knew it was a Lansing Police Department officer, and that you attempted to
I thought it was Lansing police, but it happened to be state trooper.
state trooper. Okay.
Lansing police gave up on me.
All right. And knowing that they were stopping you, you continued to move.
That's what I automatically do.
Okay.
It's like a deer running from the damn gun.
All right.
You know, you don't want to go to jail and you don't want to get shot.
All right. And this all happened on Pennsylvania on September 30th.
Yes, sir.
Okay. Anything else for the record anything else concerning the factual basis for the attempt, flee, and elude fourth, Ms. Fortuna Gill?
No, Your Honor, the people are satisfied.
Ms. Patrick?
No, Your Honor, thank you.
I find the factual basis to be knowing, voluntarily, and accurately made on the flee and elude fourth. And we'll refer to probation. We can take a look. They're gonna do a report for me, and we're gonna see what options are available at sentencing. All right, sir?
Okay.
We'll set the sentencing date for.
I've always done probation before really good.
All right,
I never
perfect.
messed up.
All right, perfect. Sentencing date of.
January 23rd at 9 a.m.
All right, January 20.
I'm sorry, 8:30.
At 8:30. And if probation is one floor down to the fifth floor all the way to the right, they'll either set up a meeting for you now or see you now. I don't know their schedule, but they'll set up a meeting, and then we'll see what options are available to us on January 23rd. All right, sir?
I gotta go down there right now.
It wouldn't be a bad idea to set up the appointment now while you're here.
Okay.
Anything else for the record in docket 25-02982, Ms. Fortuna Gill?
Not for the people.
Ms. Patrick?
Your Honor, do you need this adopted rights to add to your?
Yeah, we can make it a part of the file.
Okay. I have nothing further. Your
All
Honor.
right.
Thank you.
So we've gone through the advice of rights on the record,
Mhm.
but it is also the advice of rights. You've signed the bottom of this form I don't have the second page.
It's always like slammed back here and nobody can ever find it.
I'll have him sign it.
All right.
Thank you, Your Honor.
Thank you, Mr. Mack. If you can sign the back, all it is indicating that we've gone through the rights, and I put them on the record.
Thank you, Your Honor. I didn't know
Right,
there was a
yes,
second page.
Your Honor. Can I show you a picture of the car?
No, you can't. But you can show the probation agent a picture of the car.
Thank you, Your Honor.
All right, thank you, Mr. Mackey. You're all set.
Thank you very much.
Because they're supposed to give the yellow
Alright.
cards. He doesn't usually do that. So,
Just what they were asking.
All right, Ms. Fortuna Gill, where we proceed?
Is this Mr. Johnson?
Yes.
Okay, then that is where we're proceeding.
All right,
If we could call those matters separately, actually,
so you want
Um,
Mr. So
but right
let's
in a row
call,
is fine.
let's call Mr. Johnson and Mr. Sarts. Mr. Sarts, and then I know Mr. Behrman's, I don't know if he's here on, where you had a file that we moved.
No, we have Mr. Curtis here.
All right.
Your Honor, that's going to be a waiver of a preliminary examination as well. We're ready to go on that one.
All right, let's do Curtis first, and then we can do Mr. Johnson.
Thank you, Your Honor.
Thank you.
All right, so we're on the record in docket 2401-008. That is people in the state of Michigan versus, is it Zoe?
Yes.
Zoe Curtis. Appearances for the record, Ms. Fortuna Gill, Mr. Behrman,
Thank you, Your Honor. Randall Berman on behalf of the people.
Mr. Sarks.
Good morning, Your Honor. Jacob Sarnes, the fourth assistant public defender here on behalf of Ms. Curtis. She's president counsel table. She's staying in my right.
And ma'am, you are Zoe Curtis, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination today. Mr. Behrman, how we proceeding?
Thank you, Your Honor. It's my understanding defense wishes to unconditionally waive their right to a preliminary examination. People also unconditionally waive their right to a preliminary examination. I would indicate to the court that I had made an offer to Mr. Sarts to extend to his client of a misdemeanor. Mr. Sarts countered to me that his client has another matter pending in Eaton County. And I had indicated that if she does indeed plead to that, I would just dismiss this case. So we're going to send it to circuit court and further look into that matter. And then hopefully one of those two resolutions will come together.
All right, so negotiations are continuing on the matter, and there may be a global resolution in this matter.
Yes, Your Honor. She
Okay.
has pending charges in Eaton County. She anticipates the resolution with those by around January 16th. So Ms. Curtis requests to unconditionally waive her preliminary examination.
All right, and that's all a fair statement, Ms. Curtis.
Yes.
All right, yeah, Mr. Sarts may inquire of Ms. Curtis of her waiver of the preliminary examination.
Yes, Your Honor.
Ms. Curtis, you understand you have a right to preliminary examination day. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by attorney Jacob Sarts, and he would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it would be your wish today to waive your right to preliminary examination, have this case continue in circuit court where negotiations are continuing and there may be a global resolution in the matter. Is it your wish today to waive your right to preliminary examination?
Yes, Your Honor.
Mr. Behrman, did the people also waive their right to preliminary examination?
Yes, Your Honor.
I find the waiver of the preliminary examination to be knowing, voluntarily, and accurately made. And I will provide bind over documentation. Thank you, Megan. Thank you, Megan. All right, I'm in possession of the bind over documentation on 24010008 001-008, signed by all the parties. I'll indicate that the examination has been waived on today's date. That's 12/25/2025. It's set at $1,000 PR bond. Anything before I sign the bind over documentation, Mr. Behrman?
No, Your Honor, nothing further.
Mr. Sarks?
No, Your Honor. Thank you.
All right, your time in district court is done, ma'am. You're off to circuit court. where you'll get your next notice to appear from your attorney, Mr. Sartz. All right, ma'am? All right, anything else? That's all for the record in this file. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Your Honor.
And then we're gonna call Mr. Johnson. Oh, we have Mr. Sartz here.
Sounds good to me.
I don't even want to know, how did we let Megan know Mr. Johnson's going to be here as opposed to?
I saw Mr. Sarson.
I knew there was some, I knew there's, and I'll call these separately. Mr.
Yes,
Finnegan?
yes, please.
All right.
No.
All right, so we're on the record in docket 25 is 02422. That is people of the state of Michigan versus Christopher Johnson. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Sartz.
Is there no one down there? Megan and DK.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Johnson. He's present at council table. He's standing to my right.
And sir, you are Christopher Johnson, is that correct? Yes, sir. All right, thank you. This time set for a preliminary examination day on today's file 25-02422. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people do not have the necessary witnesses required to proceed on this matter. They were subpoenaed. Our office has attempted contact multiple times without success. I do anticipate a motion from Mr. Sartz.
Mr. Sartz.
Thank you, Your Honor. Defense moves to dismiss at this time. Mr. Johnson did not waive his timeline. He was prepared and I was prepared to proceed with the preliminary examination this morning. If people are unable to proceed, and respectfully, we request a dismissal at this time. Thank you.
Thank you. And the witnesses were subpoenaed. That was your indication.
Yes, Your Honor.
Thank you, Megan. All right, based on the defendant's motion to dismiss without prejudice. That motion will be granted. Based on the prosecutor's representations, the people are unable to proceed. The complaining victim has failed to appear today, did not answer the subpoena, and any contact with them has been unsuccessful. I will grant the motion to dismiss. Mr. Johnson, what this means is the people could reissue if they choose to, but realistically, for our purpose today, the case is dismissed. All right, sir? Yes, sir. I do have a no contact order, so you may, depending on what happens today, you may want to keep this with you. It takes about 4 hours to purge from the system, all right? All right. Anything else for the record in docket 25-02422, Ms. Fortuna Gill?
Not for the people.
Mr. Sartz?
Not for this file, Your Honor. Thank you.
You should be all set on this file, Mr. Johnson, and then we'll call your next case. We're on the record in docket 25-03182. That is people of the state of Michigan versus Christopher Johnson. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the fourth Assistant Public Defender here on behalf of Mr. Johnson on this file. He's present at council table. He's standing to my right.
And sir, once again, you are Christopher Deshawn Johnson II. Yes, okay, thank you. This is the time set for a preliminary examination on this file, 25-03182. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people are prepared to waive their preliminary examination, unconditionally, of course. It's my understanding the defendant is willing to do the same. I do have an offer to place on the record that would remain open for the first pre-trial in circuit court. Sorry, just 1 second. So the offer would be to plead to count one and dismiss the remainder with full restitution.
And is that your understanding of the offer that's been extended, Mr. Sartz?
Yes, Your Honor.
All right.
I've conveyed that offer. Negotiations will continue up to circuit court. At this time, Mr. Johnson is agreeable with unconditionally waiving his preliminary examination with the knowledge that that offer has been made and will be preserved. Thank you.
All right, thank you. May I inquire of Mr. Johnson of his waiver of the preliminary examination?
Yes, Your Honor.
All right. Mr. Johnson, you understand you have a right to a preliminary examination today. A preliminary examination is a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person who committed that crime. You are represented today by Attorney Jacob Sartz. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. It is my understanding it is your wish today to waive your right to a preliminary examination, have this case continue to circuit court where negotiations are continuing and there has been an offer placed on the record. Is that your wish today to waive your right to a preliminary examination?
Yes, sir.
Do the people also waive their right to a preliminary examination?
Yes, Your Honor.
Yeah, I find the preliminary examination waiver to be knowing, voluntarily, and accurately made. And I'll provide the bind over documentation. All right, I'm in possession of the bind over documentation on 25-03-182. Signed by all the parties. I'll indicate that the examination was waived on today's date, 12/5/2025. There's bond has been set at 3,500, 10%. Anything to come to the court's attention before I sign the bind over documentation, Ms. Fortuna Gill?
No, Your Honor.
Mr. Sartz?
Nothing further, Your Honor. Thank you.
All right, I'm going to sign the bind over documentation. Mr. Johnson, your time in district court is done. You're off to get to circuit court. Will you get your next appearance to appear from your attorney, Mr. Sartz? All right, sir?
Yes.
You should be all set. Thank you, Mr. Johnson.
Judge, should I grab Mr. Esselvila next, since we have Mr. Sartz, and I believe Jen Walt is on too, and we have the interpreter.
Oh, that's the seat. Yeah, we can go on that and then get Mr. Well, let's go on that one because we had Mr. Cornish here for a little bit.
Of course I can.
Do you have anything in the interim?
Yes,
Okay.
we can call Mr. Aldridge. That is a failure to appear.
All right.
Sorry, I didn't know you were behind me.
Oh, that's okay.
You were busy.
Just tap me.
All right, so we're on the record in 25-03415. That is people of the state of Michigan versus Wendell Aldridge. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Wanchi.
Good morning, Your Honor. And if you want you for Mr. Aldridge.
This is the time set for a preliminary examination. It was set for 8:30. It is now 10:21. It would appear that Mr. Aldridge has failed to appear for the preliminary examination. I do not see Mr. Aldridge in the Zoom courtroom or physical courtroom, and nobody answers by that name in the hallway. Ms. Wanji, have you had any contact with Mr. Aldridge?
I have not, Your Honor. It is my understanding that he's already on bench warrant status.
All right.
Since December 3rd.
All right. All right, Ms. Fortuna Gill, it appeared the defendants failed to appear for his preliminary examination. How would you like to proceed today?
Your Honor, the people would be requesting a bench warrant. Considering the defendant's history of failing to appear, the people would be requesting that bench warrant be immediate.
All right. There's currently a bench warrant out for him. That's what you've indicated.
Yes, Your Honor.
All right. Any comment on that, Ms. Wanji?
No, Your Honor.
Okay. All right, I will issue an immediate bench warrant for 25-03415 for the fail to appear of Mr. Aldridge. Anything else for the record on that file, Ms. Fortuna Gill?
Not for the people.
Ms. Wanchi?
No, Your Honor. Thank you.
All right, thank you.
I believe that's all we could handle in the interim.
All right,
Everyone else is either in custody or the one not in custody, Mr. Goodrich is in Judge Buchanan's, I believe.
this is where we just start fighting over lawyers. Mr. Cornish is here on,
Wilcox,
okay.
and that will be running.
so that's probably the next one after Molandi or Solon.
Yeah, it can be. And then I know Mr. Goodrich is covering for Mr. Austin as well.
Okay,
Both of Mr. Goodrich's are victim failure to appear, so those will be dismissals.
and then Mr. Freeman's been here waiting on Mr.
Yes,
Foreman.
that is a continuance with just the one detective witness as well.
All right, let me know when we're ready to go. So we'll probably go on a Solila
Yes,
when they bring them up, and then we can go from there.
sounds good.
That'll just be a bond motion, Your Honor.
Yeah.
Yeah.
And then
Well,
I don't know which one you want to do. I told him that Judge was looking.
oh, we have Mr. Goodrich.
Are you ready to go on Mr. Goodrich's case?
On Osmond,
Well, let me.
yeah. No.
We're ready to proceed.
Yeah, I figured.
That was fast.
I figured you would be.
Very convincing now.
So this is awesome. All right, so we're on the record in docket 25-03136. That is people of the state of Michigan versus, and how do you say your first name, sir? Abdurrahman Osman, is that correct? All right, thank you. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
Luke Goodrich from the Public Defender's Office, here to represent Mr. Osmond, who's standing to my right.
Sir, you are Abdurrahman Osman, is that correct? Thank you. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how are we proceeding?
Your Honor, the people do not have the necessary witnesses required to proceed on this case at this time. They were subpoenaed, and I do not know why they're not here.
So the CVs were subpoenaed.
It is a CCW, so I don't know that there's necessarily a CV.
Oh, yeah, but the witnesses were subpoenaed
Yes.
and are not here. Okay. And Mr. Goodrich.
Thank you, Your Honor. Your Honor, at this time, the defense would move to have the matter dismissed as we are ready to proceed.
Based on the witnesses were subpoenaed and are not here, and it appears that we've adjourned a couple times in this matter. I'm going to grant the motion to dismiss without prejudice. Mr. Osman, I don't know why the witnesses aren't here, but we are dismissing without prejudice. I think we're going to print that out.
I did, but it's not correct. Is there paper in there?
It was deep.
Let me try again.
Megan, we might need printer. I mean, we might need paper.
Paper.
Yeah.
I just put paper in there. Yeah, no, it's not.
Might be jammed.
Oh my gosh. That's why we can't have nice things.
Yeah, this is exactly why we can't have nice things. So we're stuck with that printer.
Waive the appearance. I don't think anything. Was something printed? I printed twice. Try again. Because nothing's even popping up. There was no error or anything.
Your Honor, while we have Mr. Goodrich, if we could do Nathan, that's going to be a dismissal as well.
So we may have the same problem,
Yes.
which is printing out the dismissal.
Yes.
So let's see if we can get the nollie pros, or we can do the nollie pros. Yeah.
I'm gonna re-enter.
So we will take care of the Nolly Cross. All right, that'll take care on Mr. Osmond's case. It'll be dismissed without prejudice, which means that the people could reissue if they choose to. Realistically, for our purpose today, the case is dismissed. The people might reissue on this. They may not, depending. Okay. So Ms. Fortuna Gill will be in contact with Mr. Goodrich. I have the.
No, I printed something.
Okay.
All right, let me just print again.
So that Mr. Goodrich will know if you'll get contact, Mr. Dismiss, from Mr. Goodrich if they reissue the case. All right, sir? And I'm in possession of this now. All right. So this is dismissed without prejudice. The only condition is no out-of-state travel and no assaultive behavior. So you can get a copy of this if you choose to for your own records. Because it takes about 4 hours to purge from the computer system. But otherwise than that, Mr. Osmond, you should be all set. All right, sir? All right, thank you. And then
Sorry, I thought we were off the record.
kind of off the record. What's
While we have Mr. Goodrich, if we could do Nathan.
Jeremy Nathan?
We could waive his appearance because this is gonna be a dismissal.
All right, and then Mr. Goodrich, you can be responsible for telling Mr. Nathan what we do.
One less trip we have to make Megan make.
Thank you.
All right, so we're on the record in 25-03436. That is people of the state of Michigan versus Jeremy Nathan. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
And Luke Goodrich from the Public Defender's Office, filling in for Jared Austin today and representing Mr. Nathan. Mr. Nathan is downstairs in lockup. I would waive his appearance at this
All
time.
right. And my understanding is Mr. Nathan is downstairs in lockup. We are waiving his appearance. Is that correct, Ms. Fortuna Gill?
Yes, Your Honor.
All right. This is the time set for a preliminary examination today. Ms. Fortuna Gill, how we proceed?
At this time, the people do not have the necessary witnesses required to proceed on this case at this time. They were subpoenaed, or they have been in constant contact with my office, and it is not a surprise to me that they are not here today. I anticipate a motion for Mr. Goodrich.
I was just finished writing up.
I'm just assuming at this point.
You assumed correctly. All right, based on motion, Mr. Goodrich.
Thank you, Your Honor. Your Honor, at this time, the defense would move to have the matter dismissed.
All right. Based on the prosecutor's indication that they're unable to proceed, the witnesses have failed to appear today. There's been some contact with the witnesses and that's been unsuccessful contact. This doesn't come as a surprise that they are not here. I will grant the motion to dismiss without prejudice. And I'm in possession of the order of acquittal or nollie pros on 25-03426. The people could reissue if they choose to, Mr. Goodrich, but the case is being dismissed today. All right, so I do have a GPS on Mr. Nathan. And so we will contact the private entity to have that removed. That'll be removed at the jail.
Well, to be clear, Your Honor, he's in jail.
Oh, that's so he does not
he's
go in.
never gotten the time.
Correct. Okay. Yeah, that was part of the pretrial conditions. There's no contact order with Miss Simmons. So he should carry around at least this if he's released, at least for the pendency of the day.
Okay.
And we can provide you with a copy for your records and for Mr. Aman. I think this is the wrong knowledge cross. William Aman.
Thank Thank you, Your Honor. I'll just have a seat and I'll.
All right,
for a copy of
wait
it.
for your copy and then you can provide it to Mr. Nathan.
Thank you.
I have 2503-436.
Oh, I put in 2-6. I'm sorry.
No worries.
And I was looking at it and I was gonna say. I was right. So close.
No worries. All right, Miss Fortuna Gill, where are we proceeding?
I've
lost track.
Miss Lawton is on Zoom, so, and we have, I believe we have Mr.
All right.
Solomon.
Is Mr. And did we have an interpreter?
Yes.
Yes, Your Honor.
All right. So that's Mr. Nathan.
Right.
And all right, so we're on the record in docket 2502-859. That is people, let me swear you in first, interpreter, and we'll get started from there. Got ahead of myself there. All right, sir, would you please state your name and spell your first name and last name for the record, the interpreter?
My name is Roboni, which is R-O-B-O-N-N-I-R. And the last name is K-A-H-U-M-Y-O.
Okay, K-H-U-M-Y-O. All right, and then say your full name.
Roboni Kahumio.
Please raise your right hand, sir. Do you solemnly swear or affirm that you will truly, accurately, and impartially interpret in the matter now before the court and not divulge confidential communications, so help you God under the penalty of perjury?
Yes,
all right, thank you. If I get going a little fast, just let me know, okay? All right. All right, so we are on the record in 2502-859. That is people of the state of Michigan versus Malandani Esolela. I probably butchered that name pretty good. Mr. Sartz, your appearance for the record.
Good morning, Your Honor. Jacob Sarge IV, Assistant Public Defender, here on behalf of Mr. Esolela.
And sir, you are Malandi Esolela.
Yes.
All right. Ms. Lawton, your appearance for the record from the people.
Good morning, Jennifer Lawton on behalf of the people.
All right. Thank you. This is the time set for preliminary examination. It has come to my attention that the people are moving to adjourn the matter and that people are requesting adjournment. The victim's unavailable at this point in time. And Mr. Sartz, you indicated that you wanted a motion to reduce bond. Is that correct?
That's correct, Your Honor. Just it is my understanding that the complaining witness is not available.
No. Mashahidi wote ambao tayari kuchongea wewe kutia makesi.
The cause of this delay would toll to the people.
Na kwa sababu hebu ndio hapo kunaonekana. Sasa yeye ataambia ule na iko mchongea ule funga.
But it certainly is a good cause. If Your Honor agreed with their request. So the record is clear. Mr. Esolela is going to object to preserve that this delay is not attributable to him.
Kusema kwamba wewe utaenda kukatala yote yenye walipanga, sababu na baada ya kuchongea wako wanaonekana.
All right, and Ms. Lawton, record be made by the people.
Thank you. That is accurate. The people are requesting an adjournment. The victim is currently hospitalized and therefore unavailable.
Yule mwanamke kama haonekani kwa sababu yuko hospitali angali mambo yake.
She was previously present the last time we were before this court for an exam, and has previously appeared at the probable cause conference as well.
All right, I find good cause to adjourn based on the unavailability of the victim.
Sema kwamba wanapata nani ya mzee kwa sababu wanapenda pesa kidogo sababu yule mwanamke haonekani juu anasema.
Let's get a new, two things. We'll get a new date and then you want a reduction in bond or a motion for reduction of bond. Is that correct, Mr. Sarts?
Yes, please, Your Honor. Thank you.
About how far are we looking out? I know it's as soon as possible, but by 2 weeks to get the subpoenas out, and then we'd have to get the interpreter here to make sure we had an interpreter.
Yeah, the other thing, Your Honor, my understanding is the victim will likely be hospitalized for 10 days. So we would need to at least go past that.
All right. And it takes 14 days to get out the subpoenas. So we'll put it, we'll set it for as soon as possible, but beyond 14 days.
Thank you.
Then we'll check everyone's schedule to see if there's any conflicts.
So December 19th, but I don't know if that's exactly 2 weeks out.
So we have December 19th. Does that work for everybody's calendar? That's exactly 14 days.
That works for me.
All right.
Yes, Your Honor. It should for the defense as well.
All right, we'll adjourn to just, go ahead, Ms. Lawton.
I'm sorry, my only concern is just making sure that the victim is available by that date.
All right, that's 4 days after the 10-day date, but you can let us know if that works.
Thank you.
All right, so we'll set December 19th at 9:30 for preliminary examination. And then, Mr. Sarks, did you want to be heard on bond?
Yes, please, Your Honor. Thank you.
All right, you may proceed.
Thank you, Your Honor. Mr. Isolela was arraigned on September 19th, 2025. His bond was set at $250,000 cash surety. Mr. Isolela requests a reduction in the cash surety amount. Mr. Isolela is not a flight risk. He has a good record of appearances at court dates. He has arranged, and his family have arranged, that he can stay with his brother. His brother lives about 17 miles away from his old address.
And what's the new address then?
Yes, sir, if you could please step forward. Mr. Isolela's brother's here.
Okay, just so for the court records, we'll have an address notification.
Thank you, Your Honor. It would be 5317 Aspen Drive.
Aspen spelled ASPEN.
Correct, like Aspen Mountain.
Okay.
in Lansing, Michigan. 48917.
All right, we'll update the address to reflect that, and then you may proceed, Mr. Sarts.
Thank you, Your Honor. Mr. Isalela has significant bills. He would like the opportunity to work. He is indigent right now, so he cannot afford to pay a large cash surety bond. He has an extensive and supportive family who live in the area. His parents are here. His brother is here. Other members of the community are here in support of him as well. He has extensive connections to the community. Before he was charged, he had a stable job. If he's released, he thinks he can get employment again. Concerns about safety for the complaining witness and the community can be alleviated by the use of GPS tether monitoring. Mr. Isalela would agree to a GPS tether and a curfew if Your Honor would agree to reduce his bond. We expect this case will proceed for a long period of time. He is presumed innocent. This is the second delay before his preliminary examination. So for the reasons stated, respectfully, Your Honor, I request a reduction in Mr. Isolela's $250,000 cash surety bond.
All right, thank you, Mr. Sarts. Response, Ms. Lawton.
Thank you. The people are opposed to a reduction in bond. Oh, I'm sorry, I'm having a hard time hearing, so I can't really tell if the interpreter is.
I think he's completed his interpretation of what you've just said. I think he can hear you, but you can't hear him.
Fair. We had a motion before this court to reduce bond the last time we were here. That was denied by the court at that time. There have been no changes in circumstances since the last time we were here. Other than the fact that the victim is so traumatized by this incident that she is now currently hospitalized. The defendant is.
Go ahead.
The defendant is charged with kidnapping and criminal sexual conduct in the first degree, which are both life offenses. This happened outside of the victim's apartment in the hallway of her apartment building.
Na hili ilifanyika mle wakati anataka kutembea kama
The people have serious concerns for the safety of the public in general, as well as for the safety of the victim. The victim and her family are incredibly terrified of what happened in this matter. So I would oppose any reduction in bond.
anasema ile makuta haikumbuki.
All right, thank you, Ms. Lawton. Any further comment, Mr. Sarts?
Your Honor, Mr. Isolela is presumed innocent.
Anasema kwamba wewe unasema huyu mtu hauvijui na kufanya. Huko ni sawa.
And I reiterate my previous reasons
Na ninarudia tena kwa ile mambo ya bandia.
for why a bond of reduction
Jua nini nilisema mtupunguzie kwa zile pesa ziko nyingi.
is appropriate at this time.
Njoo muda wake mtupunguzie.
All right.
Thank you.
Thank you, Mr. Sarts. So based on the motion to reduce bond, and we've set it for December 19th at 9:30, I'm going to deny the motion to reduce bond. That's mostly based on the nature of the allegations, that there are two life offenses. One is CSC first and one is kidnapping. They're both life offenses. So by December 19th, we'll have an answer concerning the facts of the case, but I'm going to deny the motion to reduce bond at this point, and then we should be available for preliminary examination on December 19th. And we will have the interpreter or an interpreter here on December 19th. That's the plan. That's the plan. Because I recognize that was a problem prior to this proceeding. So we'll see everybody on December 19th. Anything else for the record in 2502-859, Mr. Sarts?
Nothing further. Thank you, Your Honor.
Ms. Lawton.
Nothing further, thank you.
All right, you're all set, Mr. Esolila. We will see you on December 19th at 9:30. Thank you for your assistance today, sir.
Thank you.
Okay.
Thank you, Your Honor. Thank you.
Jacob. I think I got your name spelled right, but I just want to double check.
Oh, okay.
Can you just spell it for me?
Is here, let me just do this.
Oh, that would be helpful. Thank you. You're gonna get bigger. Okay.
We have Wilcox and Mr. Freeman, you're here on Foreman.
Yes, Judge.
Oh, here's Nathan's.
And the donuts. I come for the donuts.
Do you cover the donuts? Yeah, you might be responsible for bringing the donuts.
Could be.
Big Richard. Wants to go first.
This is Nathan's, who I just put it aside. I think that was the discussion.
Huh? I'm done. We need coverage on anything? Good.
Nobody's complaining.
No. That is a good way of saying that. The answer is nobody's complaining. I like that.
Yesterday they were hitting me up at 6:30 in the morning.
Yes, absolutely.
Oh, man.
But we'll let them come up and then we'll come back and take a break and walk around and so just let us know when you're ready. All right.
Like that. Have a nice weekend. I'll go too far. Not you. Oh. You have an exam, Steve?
I do.
Rock, paper, scissors?
Going first. Well, we started it a couple weeks ago, and now we got.
I got,
She
I
got
think I have,
proof.
I have a one witness exam. He just walked out the door, so I said, don't go too far. Oh, let's see who she brings upstairs. See who they bring up. Foreman downstairs.
Huh? Oh,
Foreman was in custody.
yes.
Let's see who Megan brings up. I didn't bribe her this morning. She brought the donuts, apparently. Other Steve beat me to it. No, I'm just joking about donuts. Yes, sir.
My name in the list.
So I don't know who they're bringing upstairs. Depends on who they bring upstairs.
Upstairs?
You from lockout. So it's either Wilcox or Foreman. I don't know who they're bringing up. So whichever one, then you're up. So just gotta wait and see.
Because they had that little docket list outside.
Oh, so I know who he is.
Oh, there you go. I didn't know you guys knew. Sorry.
I don't know him, but I
Yeah,
know who he
he
is.
There we go.
Oh, someone left their coffee cup. It'd be very sad. Varsity Blue. I don't expect us to take more than like 15, 20. Well, I don't, they're going to get somebody right now. So I just don't know who they're grabbing. So it's either the person for your case or it's the other person. So that'll determine whether you're going right now or after the other person. So I'm just waiting to see who the court officer brings back. Don't go too far, just in case. Or you could leave completely and I wouldn't cry. Text here. Did you leave a coffee cup in Judge Flores question mark? Trying to remember who was sitting
Maybe Caribbean-ish.
Oh, it could have been the family.
Or the family, yeah.
Usually family members don't bring coffee cups, in, just
Right.
lawyers.
Right.
I'm just gonna put it up here somewhere. In case the person shows up for us.
It was a failure to appear.
Plus it says larceny, so it seems like a lawyer's joke thing.
Yeah.
Take a picture and send it out to the list.
Yeah, there you go. Talk about instead of reward posted, ransom posted.
Jake. He just finished up. That's the alleged victim. I didn't want
Yeah.
anybody accused anybody of anything. They're really quick, and you're like, why are you talking to me?
Yeah. Yeah.
What are you saying? Are you threatening people? No, I'm not doing anything wrong.
It's funny because they had a commotion out there, and they had to get the security. I saw you walk out, I was like, oh, he's going to get another case. Who needs that?
That's my card. Here's my card. I don't even have cards.
After what you just said, man, you're gonna need a drink, so.
You got no cards. And I'm not hurting for business. That's the thing about being in a public defender's office. We don't even have to advertise. We just keep getting cases. Yeah. Business is steady. It was very presumptive of me to put my laptop over here.
They need it.
And new prosecutor done Judge Buchanan. You objected during my cross-examination. He goes, "It's called my direct." He goes, yeah, it's called cross.
Yeah.
Yeah, he decided to go into civil law.
Yeah.
He just like a week or two ago, he just like,
Yeah, I'm done with this.
I'm gonna do civil stuff. I'll be laughing all the way to watching him drive his Rolls Royce next year.
Yeah. We'll see.
Crying, wiping his tears and coming out of those. Steve's pretty good. I think Army J.
Okay.
So they have completely different rules. New to this.
Right.
It's like anything. Like
I'm
even in
good
trades.
with these rules.
Yeah.
You know,
Even-
I'm not good at this.
Like even in trades, if you go from working at like
Yeah.
welding for 20 years,
And
then you switch over to plumbing, you're gonna be like, what am I doing?
you could even say within welding, you know, because it's different.
Oh, absolutely.
So.
Yeah,
Like,
my
man,
dad
I
grew
got
up-
this weld pretty.
welded for 20 years. His age was so hard to work. He's same age, we graduated together, we grew up together, we graduated in each other's weddings and festivals. He's completely disabled and retired at the same age.
Yeah.
Yeah, that's. Very good. Just the scars you get.
Yeah.
And there was, well, you swear on your safety, because he's like, you can't keep up. You have this much work to get done in this amount of time.
Yeah.
And if you got goggles and gloves and all the other things.
Just spend time putting it on. instead of-
Well, and it slows you down. It's like, I can just make these welds, and then if I get a spark, I'm like, you got like 50 scars. You look like you went through a meat grinder on your arms. I work. I think I bought him a pair of the gloves for your Christmas. He's like, I'm not. Gonna wear this. You should send them back. Put 'em on. you think of it making it worse? Some of the guys, they're aware of the incorrect one, because they're. Yeah, that's burn iron.
So.
Always, I think.
This delay has caused me to revoke my previous offer of taking you breakfast about that. I'm not gonna do it.
I think that's fair.
Are we next or it's?
Yeah, other exams next.
You know?
Other exams gonna be next. This first one.
I bet I have a pair in my coat pocket
I know you're
right now.
here all day.
All jokes aside, let's see. I'm guessing I.
Listen, I wish I
Almost
could
always.
make it done. Everyone's frustrated with me today.
Well, you and I both get paid regardless if there's 2 files or 200 files, right?
That's true.
So
Oh.
I guess the 2 hours or 4.
Look at that.
I made it.
The sunglasses
Yeah,
kind of too, so they like,
Yeah,
look,
yeah.
look at. My brother-in-law turned me on.
Your work and cash.
So Cornish, your $20 bill out bid my $5 bill, so you're
I
next.
thought you were buying donuts.
Yeah.
That's usually how you win.
I'll just be down the hall.
All right. See you, Steve.
Get it in by 11:22. We're good.
It's gonna be tight. It's already 11.
Yeah. Saying, oh, we could bring up old cards. I was like, yeah.
I don't think she did.
No, she didn't.
Well, I mean, I don't
What?
know.
Why not?
I don't know where Megan's at.
Oh,
I don't know if she came back upstairs without a person.
gotcha,
Judge needs a little break.
gotcha.
We got the app, you can just go on and do it.
Yeah, I need 30 minutes.
Oh, we won't be done. We just play that every night. It's already 5 after, you don't have a client yet. I don't even know if she'll finish the direct exam. So, we take turns.
Gotcha.
Right.
No, I got you. I was thinking it was a different part. But your
Yes.
oh wow. So we're in trial.
No, so this is a prelim.
Okay. But still directed across.
Yeah, that's why the gentleman was here is completely different. So maybe don't talk to him.
I don't know.
I know you didn't know, that's why I was like, no,
I
just-
like the court. I like to see it.
It's all good. I told him not to go for it. I said, I think we're next, man. Hopefully he didn't leave. Good news is it's all recorded. Somebody asked me, can I go? I go, I don't need you for anything. Yeah. They're like, who are you? I'm like, who's asking?
You read that part, exactly. Around this for, times.
I didn't lie.
Yeah, never. That.
I don't know. I'd rather just get it done rather than drunk. You have a lady during the height of COVID. We sat downstairs for 6 hours. And then finally was like, I think we're going to. She got stormed out. And like literally a couple minutes later, the prosecutor's like, where's my person? I go, well, she left. I told her we were going to. We were taking to. And then she blocked the prosecutor's office on the phone. Refused to accept the subpoena. I think it's slow. It's COVID. It's going to go really slow. We used to have to sit downstairs in the lobby. Be like in chairs far apart from each other's masks on.
I was
Wait for them to fall on the case and go upstairs. You are gonna even leave.
You locked me out? Why you locking me out? We're back and ready.
All right, yeah, I know, I was trying to make sure.
Boss person tells you.
Yeah, you can have some.
I would just follow the instructions of the court.
I appreciate it.
I have this chair all the way down to the floor. I sit here during the week.
You can push it up.
I did. That's the first thing I did. I walked over and went.
All right.
Right, you can be seated. And so we're on the record in docket 25-03144. That is People of the State of Michigan versus Kristen Wilcox. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Cornish.
Good morning, Your Honor. May it please the court. Steve Cornish on behalf of Ms. Wilcox, who's in the court and seated to my right.
And ma'am, you are Kristen Ann Wilcox, is that correct?
Yes, Your Honor.
Thank you. This is a time set for a preliminary examination today. Ms. Fortuna Gill, how we proceed?
Your Honor, the people are prepared to proceed with the preliminary examination.
All right, and it's my understanding we're having a preliminary examination. Is that a fair statement, Mr. Cornish?
Yes, Your Honor.
Okay. Anything to be brought to the court's attention? The sequestration order, we'll invoke the sequestration order. One witness should not see another witness testify, but I'll leave it to the litigants to let me know, because they know the case better than I do, when to invoke the sequestration order. Somebody from the prosecutor's office, I think, is already here, so they're not a part of that. And then there's another witness. Is that witness going to be a part of the proofs today?
No, Your Honor.
All right. So with that understanding, not a witness to this, just let me know, and I'll tell one witness they have to step out while another witness is testifying.
Yep, I've already explained to them.
All right.
We have 3 witnesses present. However, I believe I'll only need 2 witnesses' testimony.
All right. Anything to come to the court's attention, Mr. Cornish?
Nothing, Your Honor. Thank you.
All right. Ms. Wilcox, you may call your first witness.
Sorry. Your Honor, I do have one exhibit. I marked it because I had stickers. Is that okay? It just says one. Or do you have to mark it?
No, I think it's all right.
Yeah, I think it's fine.
Okay. I was just trying to be helpful. It's okay.
All right. So that's one marked exhibit, and Mr. Cornish has been able to see the exhibit.
It's just the video.
Okay.
I've seen it, Judge.
Okay.
Yeah.
All right. With that understanding, Ms. Fortuna Gill, you can call your first witness.
Thank you, Your Honor. The people will call. We'll call Neil. I'm gonna mess up his name. I will spell it for the record. Upadhya.
And first name is NIL.
Yes.
Go up in front of the judge.
All right, you can come this way, sir. I'm gonna have you stand in front of me and spell and state your first and last name for the
Right
record,
here?
right here. And you spell and state your first name and last name for the record.
First name is Neil, Nil.
Okay,
Last name is Upadhyay, Upadhya.
all right. Neil Upadhyaya.
Yes.
Okay, please raise your right hand, sir. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
All truth.
Okay, thank you. You can have a seat in the witness chair right here. The microphone doesn't amplify your voice, so just project as best you can, all right, sir?
Okay.
All right. And Ms. Fortuna Gill, when you're ready.
Yes, thank you, Your Honor. Thank you for being here today. I'm just going to ask you a few questions about the incident date. So do you recall the date of August 13th of 2025?
Yes.
Okay. And do you recall anything extraordinary happening that day?
I asked for her who stole my phone.
I'm sorry, what was that?
Nothing happened, like abnormal things.
Okay, did you find yourself at a Kroger pharmacy that day?
No, not it. No,
Not
no,
that day?
Not that day, yeah.
Okay, so on the 13th what happened on the 13th?
The 13th, I went there to buy some medicine to the pharmacy, and pharmacist brought me to show the medicine to other place, and at that time my cell phone was on the table.
Okay, you left your cell phone on the table?
Yeah.
And are you at the Kroger pharmacy?
Yes.
Is this in Lansing?
Yes.
Is it in Ingham County?
Yes, it's Mount Hope.
Okay.
Road.
And is that in the state of Michigan?
Yes.
Okay. So when you left your phone on the counter, what happened next?
Yeah. The person who stole the phone was in the queue in back of me.
Okay.
The pharmacy, and I and pharmacist went to get the medicine, and then they grabbed the phone.
Okay, do you see the person who grabbed your phone here today?
I came today.
Do you see them here today?
Yeah, no.
Okay. Okay. Do you
I asked them, do you have my cell phone? I put here like that way, and they lied me.
Okay.
They got and they lied me. There were two, but one lady.
Who lied to you?
The person who stole my cell phone.
Okay.
I asked her immediately, do you have you seen their cell phone?
And would you recognize her if you saw her today?
Maybe yes.
Do you see her in the courtroom?
Object to ask and answer, Judge?
I just want
Someone
to make
asked
sure
an
you
answer, but
understand the
there's,
question.
yeah, I don't know if there's a communication barrier. So, with that understanding, to clarify, I'm going to allow the question to be asked again, but it is the second time you've asked the question.
That is true, Your Honor. Just for the record, I just wanted to make sure the witness
Right.
understood what I was asking. You said it was a woman?
Yeah.
So the woman that you confronted about stealing your phone, do you see her here?
Now?
Yes. Just be truthful. If you don't, that's okay.
I'm not sure, but
Okay,
she
that's
was
okay.
tall, white, and yeah.
Okay, but you're not sure.
Yeah.
Okay, that's okay. No further questions.
Because I saw her once there, for instance.
I understand. That's okay.
What kind of phone was this, sir?
iPhone 14 Pro Max.
14 Pro Max?
Yes.
Okay.
And police has the video of stolen phone.
Yes. Yes. I have no further questions for this.
All right, cross-examination, Mr. Cornish.
Very briefly. Good afternoon. Thanks for still morning. Good morning. You and the person at the counter selling the pharmaceuticals left the area, is that correct? You didn't see anybody with your own eyes take your phone, correct?
No.
So when you say someone took my phone, that's something somebody told you.
No. The police report and also the the Kroger authority told me the
Okay.
lady.
One second. So,
From you.
so you heard it from somebody, correct? Words. Somebody
Yeah, I
said to
heard
you.
from somebody, yes.
Okay, thank you. I don't have any further questions, Judge. Thank you.
And from police also.
Nope, that's okay. So there's a thing called hearsay, and what you've been testifying to today is hearsay. That's what other people told you. It's not what something you saw.
That's true.
Thank you. That's all I
Because
want to say.
at that time I was away.
Thank you
I
so
was
much.
just
Yep, correct.
to get the medicine. I was a little bit far away.
All right, thank you so much.
Any further questions? Redirect Ms. Fortunigo.
Not for this witness, Your Honor.
All right, sir, thank you for your appearance today. You're all set.
Thank you.
You're all done.
Yep, you can come with me. We'll go out in the hallway.
I'm assuming you had no further questions.
I do not, Judge. Thank you.
Your Honor, the people will be calling, I'll tell you next before I. Just 1 second. Jennifer Taylor. Here, let's talk out in the hallway. Well, yeah. We'll go out in the hallway.
Ma'am, you're Miss Taylor?
Yes.
Right, you can come up here. I'd stand right in front of me and spell and state your first name and your last name for the record.
Okay, Jennifer Taylor, JENNIFER TAYLOR.
Please raise your right hand, ma'am. Do you solemnly swear affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, you can have a seat here. The microphone goes right to the court recorder's ears, so please project as best you can, okay, ma'am? All right, Ms. Fortuna Gill, when you're ready.
All right, good morning, Ms. Taylor. Thank you for hanging around all morning with us. I know it's been a long morning. I appreciate your
Oh, no
patience. Do you recall August 13th of 2025?
I do.
Can you tell me what you were doing on that day?
I was working. in
Okay.
Pharmacy,
Okay, and that's what I was gonna say. Where do you work?
Kroger Pharmacy,
Do you know the address?
921 West Holmes Road,
Okay, and is that in Lansing?
Lansing, Michigan, 48910.
Okay, so Ingham County? Okay. And do you recall anything out of the ordinary occurring that day while you were working?
I just remember the guys asking where his cell phone was. And
Okay.
then, because he was talking to the pharmacist and so then they went to look at the video footage to see what happened with the cell phone.
Okay, and did you ever see any video footage?
I did.
Okay, and would you recognize the video footage of the pharmacy from that day if you were to see it?
Absolutely.
One moment. This is the video. Your Honor, may I approach the witness?
You may.
With what is proposed People's Exhibit 1?
I'm assuming she's just recognizing
It's
the,
just, yep, just for her to testify to recognizing the video. Does this look familiar to
Oh,
you?
yeah.
Does
I've seen
it?
Say that every day.
Okay. Does this appear to be tampered with or altered in any way?
No.
Does this appear to be that date we were talking about, the August 13th,
Yes.
2025? Okay, and that timestamp, is this when you were working?
Yes.
Okay. Your Honor, at this time, the people would move to have what's been marked as People's Proposed Exhibit 1 into evidence.
Your indication is that what you saw is a fair and accurate representation of People's Exhibit 1?
Yes.
The brief part that you saw?
Yes.
Any objection, Mr. Cornish?
I guess not for prelim, Judge.
All right. For purpose of prelim, People's Exhibit 1 is admitted into evidence, and then you may publish.
Okay.
I see you're getting the wire, so.
Yeah. There we go. Please hold. All right, Ms. Taylor, I'm gonna play this video now.
And so you're playing People's Exhibit 1?
Yes.
All right. And that is, that's at the 1 second mark?
Yes.
All right.
I mean, I can put it, I actually can't put it to the 0 mark. This is as good as we got.
All right.
So, Ms. Taylor, this all looks familiar to you?
Uh-huh.
I'm just gonna skip ahead here. And then, Ms. Taylor, that cell phone that's left on the desk, the counter, the pharmacy counter, that's familiar to you as well?
Yes.
Okay. I'm just gonna skip ahead in 30-minute increments here, or 30-second increments. Oh, back. There we go. And Ms. Taylor, what did you observe happen there in the video?
At this time, I didn't observe the cell phone being put in her pocket.
Okay, and do you know who that is? Have you ever had any interaction with that individual? Okay, I'm sorry, is that a yes?
Yes, I'm sorry.
That's okay. And so you have had interactions with this individual before at the pharmacy?
Yes.
Okay, and did you have an interaction with her that day?
Yes.
Okay, and do you, if you saw her in the courtroom today, would you recognize her?
Yes.
Do you see her in the courtroom today?
Yes.
Okay, can you describe an article of clothing she's wearing for me?
Blue shirt.
Okay, a blue shirt, and is that to the right or left of me, or something different?
That's to the right of you.
Okay. Your Honor, at this time, the people would request that the court recognize that the witness, Ms. Taylor, has identified the defendant, Kristen Wilcox.
And the person you have identified is sitting next to the individual in the suit, is that correct?
I'm sorry?
The person you've identified is sitting next to the individual in the suit.
Yes.
Okay. Any objection? The witness is identifying the defendant for purposes of prelim, Mr. Cornish.
Just a question or two of voir dire.
Absolutely.
Ma'am, is there anybody else in the courtroom that's other than the prosecutor and the court staff that is a female gender?
Oh, no. But I was told that, nobody else could be in here.
No further objection.
All right. Without objection, based on the voir dire of the witness, the witness has identified the defendant for purposes of prelim, and you may proceed, Ms. Fortunico.
Thank you, Your Honor. I will proceed playing the video. Ms. Taylor, at any point with your interactions with Ms. Wilcox this day, did she hand you that phone or turn it in at all?
No,
No, okay, so we just know that she had put it in her pocket. That's all we know. She didn't give it to you and you were working that day?
correct.
Okay. And you don't know that she gave it to anybody else? You didn't see that?
I was not aware that it was
Okay.
given to anybody else.
Okay.
'Cause
Is that you in the video, Ms. Taylor?
that is me.
Okay. And do you recognize the individual in the teal polo at all?
Yes,
Okay, and how do you recognize him as?
I just recognize him as the gentleman who was talking to my pharmacist looking for something.
Okay. And is that the same gentleman that you saw place his phone on the counter?
Correct.
I have no further questions for this witness, Your Honor.
Cross-examination, Mr. Cornish.
Briefly.
Do you want this? I don't.
Okay.
Okay.
Just a quick follow-up questions. When you say you saw the gentleman in the polo from the video place his phone on the counter, you didn't personally see that, you saw it on the video, correct?
I saw it on the video.
Okay, so we're all clear. You didn't have any interaction with that guy that day, did you?
No, I didn't. I personally did not have any interaction with him. He asked me about his cell phone after the fact.
Okay. Can't go into that kind of stuff, but I just want to know about your interaction. But you never saw him set the phone on the counter?
No, in the video I did, but no, because I was, you see where the computer monitor is right there on the back counter?
Yes.
That's where I was. I was at that station. So I could not see, like I could hear him talking to my pharmacist. So I did not see him personally put the phone on the counter.
Is that like a standing desk?
It's like a counter and it's just it's where we count prescriptions.
Okay, so you'd be behind the monitor,
Right behind the monitor.
so you wouldn't have a line of sight on the
Correct.
people. Okay. So that very nice lady in the back corner is recording us.
Mhm.
And if we talk over each other, she gets grumpy at me. For about 20 years now. So let me finish and then you go and then we'll go back and forth. That way she can keep a clean record, she calls it. And then you said you had an interaction with my client, the lady sitting next to me.
Yes.
You don't know whether or not the cell phone that we see being taken was returned to anybody.
Correct.
Do you have anything further? Thank you.
Good, thank you. Any redirect, Ms. Fortuna go?
No, Your Honor.
May this witness be excused?
Yes, Your Honor.
May this witness be excused from the defense, Mr. Cornish?
Yes, Judge. Thank you.
Ma'am, thank you for your appearance today. You're all set.
Thank you.
Any further proofs, Ms. Fortuna go?
The people would call Carl Jerema briefly, Your Honor. Just gonna head up here to you, Judge.
All right, Mr. Jeremy, you can come up here. And have to stand in front of me and spell your first name and your last name for the record.
KYLEJAREMA.
And that's Kyle Jerema?
Jarema.
Jerema, thank you. All right, please raise your right hand, sir. Do you solemnly swear firm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right, have a seat. The microphone, it goes right to the court recorder's ears, so it doesn't amplify your voice. So do the best you can to amplify your voice. And
Okay.
Ms. Fortuna Gill, when you're ready.
Okay,
Good morning, Mr. Jerema.
Jarema.
Sorry.
That's okay. Everybody gets it wrong. It's all
Thank you
right.
for bearing with us this morning.
Yeah.
I just have a few questions for you.
Sure.
What do you do for employment?
I'm the store leader for Kroger.
Okay.
Homes and MLK.
Okay, and that's in the city of Lansing,
That's correct.
state of Michigan?
Yes, 921 West Holmes Street.
Okay, and that's in the county of Ingham as well?
That is correct.
Okay. And were you working in that capacity on August 13th of 2025?
Yes, I was.
Okay, do you remember anything particularly different about that day?
Yes, I was approached by a customer saying that his phone had been stolen.
Okay,
And if there was something I could do to help. I immediately contacted the police dispatch, non-emergency police dispatch, so that
Okay.
an officer could speak with the customer.
and were any phones turned in at all, to
No.
your knowledge? None?
No.
Okay. So to your knowledge, was the phone ever recovered? At least
No.
not by Kroger?
No, it was not
Okay.
recovered.
Okay, and I have no further questions for this witness, Your Honor.
The cross-examination, Mr. Cornish.
No, Your Honor, thank you.
May this witness be excused from the people, Ms. Fortuna Gill?
Yes.
Mr. Cornish?
Yes, Your Honor.
All right, Mr. Jeremy, thank you for your appearance today. You're all set.
Thank you.
Thank you so much.
Any further proofs today, Ms. Fortuna Gill?
Not for the people.
Do the people rest?
Yes, Your Honor.
Any proofs today, Mr. Cornish?
No, Your Honor.
All right. Motion to bind over Ms. Fortuna Gill.
Yes, Your Honor. As the court is aware, the standard today is a probable cause standard to get these charges bound over. The defendant, Ms. Wilcox, is charged with larceny in a building. The first element of that charge is that the defendant took someone else's property. From the video that we saw today, as well as the testimony we heard from Mr. Upadia, unclear. But the testimony that we heard today from our first witness, the complaining witness in this case, he had indicated that he had left his cell phone on the counter of a Kroger pharmacy. We saw video from that pharmacy of that happening. And then we see the defendant, Ms. Wilcox, come into frame, and we see her put that same cell phone, the iPhone 14 Pro Max, into her pocket. Today we saw that video through the testimony of Ms. Taylor, an employee at the pharmacy who was working at that time. The second element is that that property was taken without consent. We know from our complaining witness here that was taken without consent. He never gave consent for anyone to steal his phone. It appears he mistakenly left it on the counter, stepped away momentarily, and then it was missing upon his return from the video that we saw today. The third element is that the property was taken in a building. The building in this case being a Kroger. We've heard testimony from all three witnesses that this occurred in a Kroger at the pharmacy counter. The fourth element is that there was some movement of the property. It actually doesn't matter whether the defendant kept the property or whether it was taken off the premises. Obviously, we don't see that happen in the video, but from the video, we do see the defendant, Ms. Wilcox, who is identified by Ms. Taylor, take the complaining witness's cell phone and move it into her pocket. The sixth element being that at the time the property was taken, the defendant intended to permanently deprive the owner of the property. We have heard testimony that the complaining witness asked about his phone, asked the people in the area about his phone, and that nobody was willing to give it up. We additionally have heard testimony from the employees at the Kroger that there was no phone ever turned in, and that the police had to be called, and therefore I believe that shows that the defendant did intend to permanently deprive the owner of that property. Additionally, the people have met location ID venue and date of August 13th of 2025 to a probable cause standard, and we would request bind over on this charge.
Thank you. Response, Mr. Cornish.
Given the court's discretion.
All right, thank you. I'm basing my opinion based on the 3 witnesses who testified, including the exhibit number 1 that was admitted of the video of the incident. The standard for preliminary examination is probable cause being the second lowest standard in criminal law, reasonable suspicion being a lower standard. But the court finds that location, venue, and date have been met. Location of 921 West Holmes in the city of Lansing, the venue is city of Lansing, Ingham County, Michigan, and the date is August 13, 2025. I believe that's been met at probable cause standard. Identification was made by a witness, Jennifer Taylor, ID'd the witness as the same person that she'd seen on that date and who was responsible, and the same person who is in the courtroom. So identification has been made. And then the elements of the offense, I have had the opportunity to see, first of all, and I'm also going to, Neil Upahida testified it was his phone. It was an iPhone 14 Pro. And then we got to see the video of the defendant he left the iPhone 14 Pro on the counter, and then Ms. Wilcox takes it and places it in her pocket. And there's no indication from any of the witnesses, including Ms. Taylor or Mr. Jeremiah, that the phone was reported as missing, or the phone was indicated it was missing at the time it was taken. Therefore, at a probable cause level, I believe that count 1 has been proven, that the larceny of building has been proven based on the motion for bind over and the motion for bind over for location, venue, ID, and date, and the elements of the offense have been answered. There's some question concerning the mens rea at the time she took the cell phone and placed it in her pocket. That can be determined by the trier of fact. But the subsequent actions concerning whether the cell phone was taken to security or told that it was missing or anything certainly strikes in response to her keeping the phone at the time she took the phone. That's evidence that Miss Wilcox did not intend to give the phone back or to turn it in as a lost phone. Therefore, I find by a preponderance evidence that the crime has been committed, a larceny in a building, and I'll bind over as charged. So the examination was held on today's date. That is December 5th, 2025. And this is bound over on the charges on the complaint. Bond is set in the amount of $1,000, 10% by the magistrate. Anything concerning this file, on this file before I sign the bind over documentation, Ms. Fortuna Gill?
No, Your Honor.
Mr. Cornish?
But nothing from the defense judge.
All right. I'm going to sign the bind over documentation. Ms. Wilcox, your time in district court is done. You're off to circuit court where negotiations are going to continue. And you'll get your first notice to appear in circuit court from your attorney, Mr. Cornish. All right, ma'am? All right, that's all for the record in 2503144. Thank you for your appearance today.
Thank you, Your Honor.
And then Mr. Freeman, yeah, Mr. Foreman, is that correct? Mr. Freeman? You have Mr. Foreman? All right.
Foreman, yes.
We're gonna need the transcript.
If I want one later, I'll tell you.
We're gonna need the transcript, so.
Oh, she's ordering, then I better take it.
Yeah, you better take it, just in case.
Yes, sir.
Heard you crossed over.
Yes, the answer to that question is yes.
I know.
I think the answer to question 2 is also yes.
Yeah.
I don't know if you answered your law school
I
exam,
have
sir. I passed his.
Passed some law school exam. You did us proud, Mr. Cornish.
Yeah, and when I'm sitting back here and I see one of the other lawyers, not necessarily a public defender, but anybody, I can't help it, I take notes.
That wasn't your coffee cup, was it?
No,
It's-
this. My charger.
Of course, what I'm saying.
I set it up here. So that it belongs to-
Well, you're fine, but
Coffee cup.
I've learned there are three types of cases we try. There's the cases we wish we tried, the case we actually tried, and the case we wish we would have tried. And you only learn that after the fact, like, God, I wish I'd asked this. God, I wish I'd asked that. That's, that's a truism. But it takes years to get there.
Oh, sure.
I found a coffee cup sitting in the chairs and I sent an email asking if it was one of theirs. And the response was 610.
I don't know what that means. I don't know what that
either.
means.
So.
Mr. Freeman, I think yours is
Oh, no,
a
I just,
continuation.
I just,
Yes.
I don't think it classifies under the definition.
Well, yeah, it may not.
So. I think there's a requirement of more than monetary placement.
That's something to look into. As far as
Oh, you're fine.
yeah, something to look into. I'm uncertain about that, but at a probable cause level is a different level than. I would think she's got bigger fish to fry than this.
This is we have a policy. If you have one case, you get the second.
Yes, you've got the second.
So this is the second.
I don't think
The
she's
stabbing
about
case
this
that I'm
right
working.
in 25-02321. That is People of the State of Michigan versus Kashawn Foreman. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Freeman.
Thank you, Your Honor. Good morning. Stephen A. Freeman, Public Defender, on behalf of Defendant Mr. Foreman, who is at council table.
And sir, you are Keyshawn Foreman, is that correct?
Yes, sir.
All right, thank you. This time set for an adjournment to a preliminary examination. We started on November 14th, 2025. I think we had 4 witnesses on that date. An exhibit was admitted, and then we adjourned to entertain another witness. Is that a fair statement, Ms. Fortuna Gill?
Yes, Your Honor.
Okay, and that's your understanding, Mr. Freeman?
It is, Your Honor.
All right. With that understanding, the same, I will leave it to counsel for the court to invoke sequestration if necessary. You know the case better than I do. One witness shouldn't watch another witness testify, as you know. And we'll have the additional witness testify any further proofs of Ms. Fortuna Gill.
Yes, Your Honor. The people would be calling Detective Christopher Benzing.
All right. You may proceed.
Thank you.
All right, Detective Benzing, you can come up here. Please stand in front of me and please state your first name and last name for the record.
Christopher Benzing.
All right. You have to spell your last name for the record.
Benzing is B-E-N-Z-I-N-G.
Please raise your right hand, sir. Do you solemnly swear affirm to tell the truth, the whole truth, nothing but the truth under penalty of perjury?
I do.
You can have a seat. The microphone goes right to the recorder's ears, so it doesn't help with amplification. So please project as best you can. And Ms. Fortuna Gill, when you're ready.
Good morning. Thank you for being here, Detective Benzing. Can you tell me what you do for work?
I'm a detective with the state police.
Okay. And how long have you been doing that?
I've been in an investigative capacity since 2021.
Okay. And how long have you been a police officer overall?
2018 was when I started.
And are you familiar at all with this case that we're here today? Do you know what case you're here for today?
Yes. Yes.
Okay. And can you tell me about your involvement with that case when you were assigned the investigation?
Yeah. So my unit is embedded with the Lansing Police Department's Detective Bureau. And I was assigned this case early in July. I think the incident happened the night of July 4th to the 5th. And I think due to other cases, I first looked at it maybe a day or two later.
Okay, and can you tell me a bit about your investigation?
Yes, so by the time it got to me, the patrol officers had already identified recovered some security video that showed a suspect vehicle and a suspect.
Sorry to interrupt. What was the suspect vehicle?
Yeah,
in the video?
it was a white GMC.
Okay.
Or Chevy. There are 2 vehicles that are nearly identical in features. So we were able to narrow it down to that. Most of the video was from the nighttime, so sometimes that can distort color, but we also had descriptions of it as a white vehicle from eyewitnesses.
Okay. And so how did you go about narrowing it down from there?
Certainly. So we have the capacity to review license plate reader footage, so vehicle footage, and narrow it by vehicle type, or to search by a vehicle type or color rather than narrowing it by a plate.
Okay.
So it's a little bit of a needle in a haystack approach, and I think it was at least hundreds of possible matches. And then once you it's almost like a child's game where you try to match the 2 photos or find the differences in the 2 photos. So once I started narrowing that down, things like roof racks, trim packages, year models, vehicles that were close to being the target vehicle, but were in fact the wrong make or model, ended up with only about 10 that were actually true matches to the suspect vehicle.
Okay, and this is all from like neighbor ring cam footage,
Yes,
things like
so,
that?
so I think we had two different sources of video that showed the vehicle from a few different angles and a few different times because there was some movement through the neighborhood, but what appeared to be the same vehicle.
Okay, so you're down to 10. Tell me how you narrow it down from
Further?
there.
Yeah, so then I start, so with the license plate reader is a photo of the vehicle, but it also provides the plate. So then I use the plate information to identify the registered owners, and then other individuals who were registered to the same address.
And this was for all 10? You did
Yes.
this for all 10? Okay.
Correct. And some of them were, I think, one or two were from out of the city of Lansing, and based on the case facts, I didn't think they were likely to be relevant. And really only one matched the victim description of any of the accused, not the registered owner, but the registered owner's daughter.
Your Honor, I'm going to object to the witness referring to anyone as a victim. The testimony and evidence before the court thus far is that the woman who was in the house didn't see anything, and the gentleman wasn't even home. So
Your Honor, if I may, I was gonna have a follow-up question there as well to clear the record. It's my understanding that Detective Benzing is talking about the person that our complaining witness met earlier in the day, not who witnessed the shooting firsthand. I'm about to ask that question right now.
Right, and then I just warned the witness to just use names, just use their names, yeah, so that'll keep you out of the alleged victim, or just use the name of the person.
And if the gentleman could keep his voice up just a little bit.
Yeah, you might have to speak up, just the request has been made. With the understanding, any information that he's receiving and basing the investigation on is not offered for the truth, I would think at this point.
Absolutely, Your Honor.
So it's not hearsay. All right, so at this point, the objection is sustained, but I'll allow you to ask the follow-up question.
Thank you, Your Honor. So when you say, when you refer to the accused, that I believe you said a complaining witness had mentioned, who do you mean by that? And I guess how do you get there?
So let's back up a few steps, actually, because it's not the accused was not the one who appeared to be a relator. I found a connection to the registered owner of the vehicle. It's the female, I believe her name is Empress.
Okay.
Empress showed a connection to that vehicle, and that was based. And then the person I'm describing on the other side would have been Antonio Williams. And then also the images he provided that were at least consistent, if not identifying to be Empress.
Okay, and do you know how the complaining witness would have known these people if the complaining witness wasn't present during the actual shooting?
So there had been a previous confrontation that day.
Okay.
And he had confronted both this female named Empress, he being Antonio Williams,
Okay.
and then later Keyshawn Foreman.
Okay, so Antonio Williams being the complaining witness, just for the record, I know I've been using that term. So, so Mr. Williams knew Mr. Foreman from earlier in the day, was your understanding?
Correct.
And one of the 10 vehicles that you had narrowed down that was not associated with Mr. Foreman per se, it was associated with a woman named Empress? I just want to make sure I'm understanding.
Empress resided at the same address as the individual who owned the vehicle, and that address was, I think, 0.2, but less than a mile from the venue on Rio Road.
Okay, so that's less than a mile away from where the incident took place.
Correct.
Okay, thank you. And then how is Empress and Mr. Foreman, how are they connected at all?
They are in a dating relationship, and I state that based on information from other law enforcement officials, and then reviewing related police reports from a previous shooting incident.
Oh, okay, so you're basing this off of?
I beg your pardon, Your Honor, counsel, forgive me.
You're okay.
If the witness won't speak louder, may I please sit in the jury box?
You can rearrange your sitting for your to be able to hear the witness. I can hear the witness, but if the witness can speak up, that'd be helpful also. And Ms. Fortuna Gill, you may proceed.
Of course. And so all of this information that you're getting, this is all from other police reports, and is that your involvement with those other cases?
I was not involved
Okay.
in that case. We received information that we pushed to the public some still images, and we received a tip that named Empress by first name and Keyshawn Foreman by first and last name, I believe. And then in researching that was how I came upon this previous shooting incident.
Got it.
And also, their relationship was known to law enforcement.
Okay, got it, understood. So after you narrow it down here, what's your next steps?
So between the tip that advised us and the vehicle connection, I did think, and the fact that when I retrieved Mr. Foreman's Secretary of State image, it did appear to be consistent with our suspect. I then had a photo lineup constructed both for Empress and for Keyshawn, and then had that administered by another officer who's not familiar with the case to Antonio Williams.
Okay, and to your knowledge, did Mr. Williams pick either of those individuals out?
Yes, I was present in the room.
Okay.
He took several. He looked through the 6-pack lineup several times for Empress, and I would note that her hairstyle was very different. We just had to use the Secretary of State image we had, and then he was very confident in Keyshawn Foreman. The first time through, he said, I don't want to misstate. I do have it in my report exactly what he said, but he was quite confident that was the individual he had contact with at his family gathering.
So you did observe Mr. Williams confidently pick out Mr. Foreman as the individual he had a confrontation with earlier in the day?
That is correct.
Okay. I have no further questions for this witness at this time, Your Honor.
All right, thank you. Cross-examination, Mr. Freeman.
Thank you, Your Honor. Detective, I'm going to ask you a few questions, and if you don't remember or you don't know, and if that's truthful, that's the correct answer.
Certainly.
I'm going to ask you, please don't guess. All right, thank you. Unless someone asked you for, well, approximately, then, you give your answer in that regard. All right, so you were not involved in this case on July 4th. You came into it after. Does that sound right?
That is correct. I was not present for the on-scene investigation. That's what you're asking.
And what were your, I don't know, instructions? What did you understand your task to be?
To identify the individual who was seen in the video shooting at the venue.
Okay. And what was the first thing that you did?
I think the first thing I did, the story, the account of the earlier confrontations in the day was quite baffling. Both the Empress or the woman we identified as Empress and Keyshawn Foreman were adamant that their daughter played at this house, and the gentleman who lived there was saying, I don't know what you're talking about. That was very confusing to me. So I sought to try to identify, was there a different person who lived in the house previously that he might have been referring to or had some prior connection with. So I investigated that for a short time. And then I think the pull of the license plate readers was the first step that got some traction.
When did you find out about this afternoon confrontation?
That was documented in the original report. So again, I think there was a day or two where I was working on a different case before I got to this one, but within a matter of days.
And did you develop a theory on your own, or did you adopt someone else's to suggest that the individual who had been in the driveway and near the house earlier in the afternoon may have been the same person who fired at the house?
I think Antonio Williams offered that theory to patrol, and that was documented in their report. And then the individuals wearing the same clothing and same vehicle is seen for both the confrontation and for the shooting. So I guess I would say I adopted it fairly readily. I wouldn't say I was fully committed to it, but it seemed like a reasonable theory to work on.
Was it your understanding that someone had identified a white Chevy or GMC as the vehicle operated by Mr. Foreman
I would
in
actually,
the afternoon?
I would actually say that it was specifically identified as the Chevy. I believe it's an Acadia. And in my review, it was apparent that the Acadia and the Traverse are excuse me, it was a Traverse, was what we were told the vehicle was. However, a Traverse and an Acadia are essentially indistinguishable.
Did Mr. Williams identify a motor vehicle that he associated with my client from the afternoon?
Oh, I don't recall if he specified. Yeah, I don't know that.
If it's not in any of the original LPD reports, you made no such finding, is that right?
No such finding for what?
In other words, there was no information from Mr. Williams or anyone else present. No witness said, gave a description of the vehicle that was being driven, perhaps by Mr. Foreman in the early afternoon.
I would have to review the report. I do believe he did describe that. I do not recall.
Yeah, thank you. Did you have an opportunity to review some security footage from the neighbors and their security cameras?
Yes.
And did you do that along with Mr. Williams at the same time?
No. So when I review it, it's already been entered into property or evidence in our report writing system. So it was not in accompaniment with Mr. Williams.
You viewed various video footage that had already been apparently copied or, received by the LPD department, and that they already had secured. Is that fair?
That is correct.
All right, thank you. Do you know whether the security camera footage that you saw was the same that Mr. Williams saw?
I don't know what video he did or did not see, so I guess I can't comment on that.
Okay. Is it your testimony today that the person sitting next to me here, Mr. Foreman, that you could identify him from any of the neighbors' security camera footage?
Absolutely not.
Okay. And you saw the video footage from Mr. Williams' security camera?
I believe what I viewed was still images. I don't recall if any of it was video.
Okay. In any event, is it your understanding today that neither you nor Mr. Williams could identify the individual from the video footage from his security camera?
I could not identify him. I could say that he was consistent with that person. And I don't understand, I guess, as far as how.
I'll break it down. And I know you weren't here, but Mr. Williams testified, and he was talking about, I think he said ring doorbells or some kind of security system. And he was suggesting if he didn't say outright that a good number of his neighbors had those. And I was just curious.
Objection, Your Honor. I think Mr. Freeman is summarizing some other witnesses' testimony, and I don't find that appropriate. I also think he's mistaken. I think that he means to be talking about Mr. Davis. But you're asking about Mr. Williams. I mean, there's a sequestration order in place.
I think they were both asked about the video ring cameras, but I don't remember. I can't sort out one witness from the other. With that understanding, I think the witness is testifying as to the investigation and what he did in the investigation. So we'll leave it at that. Okay. So the witness can testify as to why he did what he did in his investigation.
Okay. Thank you. All right. I'm not going to ask you to go in great detail, but is it your understanding that there are various law enforcement cameras around Lansing?
Yes.
And what's your understanding as to what their purpose?
I guess it would depend on which cameras you're talking about. I think there are a number of different purposes and don't all share the same.
Any that were employed in your investigation?
So what I used were stationary license plate reader cameras, and they capture a still in, well, what I use, I don't know what all they capture, but what I used were still images of vehicles that were taken that capture both, ideally capture both the vehicle and the vehicle's plate is how they're positioned or intended to function.
Is that as loud as you can speak?
Sorry.
Okay. And is that a situation where you've got to sit in front of a computer screen and scroll and scroll and scroll and look for things, or how does that work?
In essence, yes. It's two separate documents. It's an image and then a corresponding vehicle, like an Excel document that shows the plate. I think it shows the location of the camera. I think it shows the date and time the image was captured. So some basic data to go with the images.
Is the location of the security camera significant? That is to say, certain intersections, or were you sensitive to looking in a particular area of the city?
Oh, no, I asked for all images from any camera taken that day. It was a voluminous amount of information.
And you asked for an entire 24 hours?
I would have to review. I think I narrowed it slightly. I think I recall it as being not a full 24 hours. I think it was a time period capturing both maybe an hour or two before the initial confrontation through a few hours after the shooting, but I don't think it was a full 24.
Were you attempting to identify a particular vehicle that may have been associated with the encounter of the afternoon, or was your role to try to find a vehicle that was seen at 10 o'clock at night?
I was trying to find matches to the suspect vehicle description we had based on the witnesses and the video we had.
All right.
Not a certain time frame that was moving around. If that was your question.
No, I'm just not asking the right question. There's two scenes, okay? There's an afternoon scene when Mr. Williams said he had this confrontation with somebody, okay?
Okay.
Okay, that's scene one, afternoon. Scene two is 10 o'clock at night when there's a shooting.
Okay.
Hours apart. Were you trying to identify the vehicle that seems to have been in use at the 10 o'clock hour or the early afternoon hour?
Okay. So first I would say by that accounting, there'd be three scenes, because there was an initial contact with Empress and a juvenile female, and then a contact with Mr. Foreman, and then a shooting. So three different scenes. And it was my belief that I was looking for a vehicle that was one and the same for all of those.
I see. And you're testifying today, confident that theory proves to be true?
That all three of those incidents were connected?
Yeah.
Absolutely, yes.
Okay. You say you at one point you had narrowed it down to 10 vehicles. How did you come up with the 10 vehicles?
So what I did was, it's hundreds of images, but when you start looking at, because I had fairly accurate or fairly detailed images of the vehicle I was looking for. And then if you look for instance, most vehicles have either a roof rack or at least the rails for a roof rack. And the vehicle I was looking at did not have those, which helped narrow down quite a few. The trim packages change by year and even within the year itself. So you can narrow things that don't match the trim package. There's one other, I think there's different models for the fin. That's like the antenna for your cell service in the vehicle. The vehicle's equipped for that. That helped narrow some down. I think I documented in my report kind of what I used. Tinting, window tinting is another one I used.
And you, in your mind, in your opinion, you narrowed it down even further to a single vehicle?
one vehicle had caught my attention, as at least none of the others had anyone associated with them that matched the descriptions of my accused or of the two people or the images we had of the two people that I was looking for. And it was about and I would add that it was about the same time that I had identified that I received this tip that this woman named Empress was the woman in the.
We're going to get to that tip in just a moment, but thank you. So so did you narrow it down to a single vehicle eventually?
I had narrowed it to one that seemed the first place to start as the most likely to match.
And did you have the license plate for that vehicle?
I did.
And you ran it?
I did.
And the registered owner was?
It was a male. I don't recall his name. I think it's in my report if you'd like me to refresh my memory.
Was the last name Foreman?
I don't believe it was.
Okay.
I'd have to review my report.
Did you make contact with that owner?
I did not.
Do you intend to?
No.
Okay. Now we're at a point where we're going to talk about that tip. Did the state police or LPD, did law enforcement put together some kind of a television commercial asking for the public's assistance?
I don't know what form the media took. It was released to the public. We do something every week called Crime Stoppers, and we may release images or descriptions of crimes and request information.
And the telephone number, if you know, was that, I guess, connected to the state police or Lansing City Police? Or
my understanding is it's an entity separate, that it's a group called Crime Stoppers. I know that the information has to pass through, at least I'm aware of, 2 different sets of hands before it gets to me to ensure some anonymity. And anonymity in it, and I'm going to try.
The individual who supplied this information, we'll keep calling it a tip. Did they identify themselves?
Again, I don't get the information in its raw form. It's passed through some hands and it's been washed of some identifying information. So I don't know if they identified themselves when they provided the tip. By the time the tip gets to me, it does not have identifying.
In your mind, it's anonymous?
Yeah, yes.
Okay. And receiving an anonymous tip information, is it fair to say that in this particular case, that did not indicate to you whether this person had ever given information to law enforcement in the past? You didn't know if this tipster had given information in the past for any reason?
That would be accurate. That would be accurate.
Okay, thank you. Did you ever have a face-to-face contact with Mr. Foreman?
I did not.
Are you aware as to whether any law enforcement person, regardless of agency, interviewed him?
Can we clarify? He's been interviewed a number of times. If you're asking about this, I think he brought this matter up during an interview on a different matter.
I see. That Mr. Foreman brought this up?
That is correct.
Okay. Were you present?
No, I was not.
Are you aware, and this can just be yes or no if you like, are you aware as to whether any law enforcement officer recovered any kind of a firearm as a consequence of this investigation?
I am aware that no firearm was recovered that we know to be related to this case.
I can't hear you.
I am aware that we have not recovered any firearm that we believe to be related to this case.
Thank you. Ultimately, this vehicle that you narrowed down to just one, what was the make and model?
I believe it was the Chevy Traverse.
Thank you. Do you recall how one might open the back end of that vehicle?
I think it's what's called a lift gate. I think is the term, but it's a handle that you lift up or that automatically opens and a hatch that swings up.
And it, just for purposes of the record, it's an SUV vehicle, right?
Yes, that is accurate.
It opens differently than the driver's side front door.
As in that it opens at a north-south axis rather than east-west axis, should we say? Yes?
Yeah, if you were going to get in the car and drive it, the door opens a particular way.
Yes,
The one in the back doesn't open that way, right?
I would agree.
Okay. Did any of the security camera videos you saw show the a white vehicle at 10 o'clock at night on July 4th opening by way of an old-fashioned trunk or by way of a however you referred to it, a flip
A
door?
lift gate?
Yeah.
Are you asking if a lift gate was opened?
Yes, I'm asking that. If you saw any video footage from the night in question of a person perhaps opening the back end of a vehicle, and as to whether, if you did, that the back of the vehicle that they were at opened with a lift gate or in a traditional style door. You follow?
I'm thinking the problem is I look at a lot of video and I think I do recall that opening from the back, but again, because I watched so many, I would prefer to refresh my memory with the video of the shooting before I made a definitive answer to that.
Thank you. But you and I are clear that the old fashioned way of a trunk lid coming up versus, well, strike that. And you told me no weapon had been recovered. You already told us that, right?
Correct.
Okay. Now, you mentioned something about clothing. Was clothing something that was significant in your investigation?
I noted that the individual who shot at the house was wearing identical clothing or what appeared to be identical clothing to the individual who'd been present and had a confrontation with Mr. Williams earlier today.
And how were you able to determine that?
Based on the video of the two incidents.
Okay. In the afternoon incident, you didn't see any video of Mr. Foreman here operating a vehicle or entering or exiting a vehicle?
I don't think so, no. I think what I had was still images.
Who is this person you talked about on direct named Empress? Who's that?
That would be I think her last name is Knox, but I'd have to review my report. But in any case, it appears to be Keyshawn Foreman's significant other. I think they have, actually, I'm not sure they have children counted, but they appear to be in a dating relationship.
She appeared to be in a dating relationship with the gentleman sitting next to me?
That is correct.
Okay. You interviewed her, did you?
I did not.
Were you present when someone else did?
No.
Do you know whether she was interviewed by law enforcement at all?
Again, about this matter, I do not believe she was.
Okay. And the registered owner of that single vehicle you narrowed down, you did not make any contact with that person?
That is correct.
And did you tell me that you're not aware of it as to whether any law enforcement person did?
I can say no one did about this matter.
Okay. Do you know whether any physical evidence was collected as a result of law enforcement investigating this?
Yes.
And what would that have been?
That would be fired cartridge casings.
Anything else?
That's what I recall. That's what I recall.
All right. Thank you very much. We're almost done. Judge, if I can have 15 seconds. Sure.
Your Honor, that will conclude my cross-examination. Thank you.
All right, thank you. Any redirect, Ms. Fortuna Gill?
Briefly, the infamous briefly, but for real. Detective Benzing, you testified on cross-examination that you were very confident that all 3 of these scenes were related. But you didn't get an opportunity to explain why. Explain to me why you're very confident that all 3 of these scenes are related.
Correct. I think we've laid out a number of reasons that all point to that, and I think most recently, Mr. Foreman was interviewed and described this incident and described, in fact, going and confronting Mr. Williams on the 4th. And I think that further added to my confidence that we did have a series of events that were connected. And I think it also helped explain what appeared to be a very strange interaction that I described, where they're insisting that the relative comes and plays it here, and Mr. Williams says he doesn't have any idea what's going on with that. That interview kind of shed some light onto that situation as well.
Okay, one more question. And I do believe you touched on this earlier, but there's been a lot of questions and I just want to make sure that the record's clear. If the registered vehicle that you narrowed this down to was not registered to Mr. Foreman, how is it that you are confident that Mr. Foreman was driving that vehicle?
Primarily based on the eyewitness's identification from a photo lineup as the individual who was involved.
Okay, thank you. No further questions.
Oh, actually, I would add one more point to that.
Sure, go
if
ahead.
That's okay.
Sure.
Mr. Foreman fled the state and was recovered out of state. And prior to that, that same license plate was identified in the same area as where he was recovered from.
Okay.
Which would, I think, further point to a connection between he and the vehicle.
Sure. And which state was that, if you recall?
I believe it was South Carolina.
Okay.
I believe it was South Carolina.
Something down south.
Yes.
Okay.
Any follow-up any follow-up questions on redirect, Ms. Fortuna Gill?
No, not for the.
And Mr. Freeman, do you have any, I'll let you some follow-up questions on cross.
She did open up something else, I think, Judge. You were talking about, I think you used the word description, and then I thought I heard you use the word identify or identification in some of your answers. In your investigation, did you make a distinction between someone giving a description of something they saw versus identifying what they saw?
I think I was using those terms to distinguish between, for instance, the video being consistent with the description provided or consistent with an image of Mr. Foreman, but not of identification quality to the point where it would be a match from facial recognition. Does that, I was trying to be careful to avoid that.
I would too. Okay, thank you. You put together a photo array, did you?
I did not. That is done by a third party who's not involved with the case.
All right, you didn't make the selection as to which photographs, but did you present a photo array to Mr. Williams?
Also, that is not accurate. The photo lineup is done double blind, so an officer is brought in who has no connection or involvement or awareness of the case, and he conducts the lineup.
And are you aware today as to whether that array presented to Mr. Williams was an attempt to identify Mr. Foreman or this woman that you referred to?
Well, to be clear, two separate lineups were done. One was for the purpose of identifying the woman, and one was for the purpose of identifying the male.
Okay, and to whom were these presented?
Mr. Williams.
And is it your understanding he identified Mr. Foreman as the person in his driveway in the afternoon?
That is accurate.
And what's your understanding as to his identification of this woman known as Empress?
Why was that significant? How did she fit in?
Oh, I think it's relevant that the fact that we didn't identify only one, but in fact, two people who are known to be connected to each other and are both identified in a tip are now being identified by our eyewitness victim, whichever, it wasn't clear to me where, but the contention was there.
Your Honor, it's come to people's attention that Ms. Knox is present in the courtroom today. There's been a lot of talk about her today. The people do not anticipate calling her as a witness at any point. Police did not speak to her at any point during this investigation. I'm unclear what the defense would plan to do, but I just wanted to bring that to the court's attention.
Does the defense intend on calling Ms. Knox as a witness?
No, Your Honor. Thank you.
Perfect.
Right.
I just wanted to make sure. Thank you.
All right. I think that's all that I have, unless you used any other technological equipment, cameras or recording devices of any kind in your investigation or
Well, I think the interview that Mr. Foreman gave was audio recorded. I think it was audio visual recorded, but it was certainly audio recorded. The lineup that was presented, that an audio visual recording of that was captured. I don't recall what other things I videoed or otherwise recorded during the course of my investigation.
I'm halfway to my chair, but as I'm going, I refer to a lineup as a physical corporeal lineup at the jail. Otherwise, if they're pictures or photographs, I suggest that's a photo array. Do you use those same terms, or do you call the six-pack a lineup? I just want to make sure we're using the same language.
Yes, this was a photo lineup.
Okay. You've been talking today about a photo lineup.
That is correct.
Do you have any information as to whether an actual corporeal lineup was conducted at the jail?
I did not request one, no.
And you're not aware as to whether anyone else did?
I would say I don't think one was done.
You're not aware?
I am not aware of one.
Okay, thank you. Thank you, Judge.
Thank you, Mr. Freeman. Anything else for the redirect of Ms. Fortunigo?
No, Your Honor. This witness may be excused from the people.
From the defense, may this witness be excused?
Yes, Judge. Thank you.
Detective, you're all set. Thank you for your service.
Am I allowed to stay and watch?
Yes.
Yes.
Any further proofs today, Ms. Fortunigo?
No, Your Honor.
Motion, any proofs today from the defense, Mr. Freeman?
Thank you for asking, Your Honor. The defense offers no proofs.
All right. Motion for bind over Ms. Fortunigo. And I recognize that we've had a bifurcated preliminary examination. So I'll leave it up to you how you want to proceed.
Yes, Your Honor. I have some pretty extensive notes, so I can refresh everyone for the testimony that occurred from November 14th. I do just want to confirm with the court before I start my bind over argument. I'm looking at a complaint that has a count 1 assault with intent to murder and a count 2 discharge of a firearm at a building. I just want to confirm with the court that the court doesn't have one that says in the alternative.
I don't have one in the alternative. I have 4 counts and the habitual second offender notice.
Okay, perfect. That is what I have as well. So I'm glad we're all on the same page.
So motion for bind over.
Yes, thank you, Your Honor. Mr. Foreman is charged with 4 counts today. Count 1 being assault with intent to murder. Count 2 being weapons discharge at a building, and then 2 counts of felony firearm associated with those. And as the court pointed out, there's also a habitual second offense notice. We have heard from 5 witnesses throughout the course of 2 separate days on this case. I will go through the elements of each count and try to fill in with witness testimony. The first count being the assault with intent to murder requires first that the defendant tried to physically injure another person. We have testimony from Antonio Williams. This is the complaining witness. Testified that Keyshawn Foreman, the defendant, he identified the defendant in court as the man who showed up to his home earlier that afternoon and was very angry about Mr. Foreman's daughter playing at the complaining witness's home. Mr. Williams indicated that he had never seen this man prior to this. He had never seen his daughter, or who he assumed to be his daughter's mother, which we have heard lots of testimony about today, being Empress Knox. The complaining witness, Mr. Williams, also testified that the defendant yelled, "I'll be back," very angrily at the end of the driveway, and then had left, and that was the end of that conversation. Later that day, Mr. Williams pulled up to his home after taking the children to watch fireworks, and there had been bullet holes all over his home. We heard from this Mr. Williams, we heard date, location, and venue. He also did identify Mr. Foreman as the man that he had spoke to earlier that day. Additionally, we heard from Demetra Gonzalez. She testified that the shooting did occur at nighttime while she was home. She is the mother of Mr. Williams, and they reside in the same home. This was approximately 10 p.m. when she was in her bedroom. She testified that the bullets were very close to her and that she additionally had fragments stuck in her leg following the shooting. While Ms. Gonzalez did not see the shooting happen, apart from the bullets being right next to her, she didn't see anything outside. She could testify that there were approximately 8 shots into the home and that they were very close to her and in the bedrooms. I think from this we can gather that the defendant, Mr. Foreman, did try to physically injure another person. He knew that there were people who lived in this home. He had been there earlier that day and had shot into bedrooms specifically that would have been occupied at about 10 p.m. And one of those bedrooms was occupied by Ms. Gonzalez. And additionally, we heard from Mr. Davis, a neighbor, who testified to seeing Mr. Foreman go into his vehicle, pull out a gun, and then shoot up the house, being Mr. Williams' house. And Mr. Davis did testify that he was too far away to be able to identify Mr. Foreman in person at that moment, but that he went back to his home later and zoomed in on his Ring camera footage and identified Mr. Foreman. That's the testimony of Mr. Davis. He said that he had recognized Mr. Foreman from the neighborhood, that he had seen him at the liquor store. And he said that he did this only about 10 minutes from the actual shooting on his Ring camera. Now, it's true that we do not have this footage. It does not appear that the police have this footage, but that was the testimony of Mr. Davis under oath. What we do have is we did see a video of the shooting from a Mr. Yoke, another neighbor who did not see anything, but was able to provide us with that Ring door footage. And we saw the white SUV that was described earlier in the day for Mr. Williams. Let me try to organize. So the second element is that when the defendant committed the assault, he had the ability to do so. We have testimony from Mr. Davis that it was Mr. Foreman who had shot up the house. We have testimony from Detective Benzing that all 3 of these incidents are related. He testified that he was very confident to that Mr. Foreman was wearing the exact same clothing in the video, or in the stills rather, that Detective Benzing was looking at to when he was confronting Mr. Williams earlier that day. Additionally, Detective Benzing was able to narrow down the vehicle to one vehicle that was in the area that matched the description and the stills of that white vehicle, the same vehicle that was there in the afternoon, that was there at the shooting, the same white vehicle that Mr. Davis testified to seeing Mr. Foreman take a gun out of. And additionally, the same license plate matches up to where Mr. Foreman was extradited from in South Carolina. The third element of assault with intent to murder is that the defendant did intend to kill the person they assaulted. I would argue that that shooting into a home, is occupied into the bedrooms approximately 8 times is intending to kill the person on the other side of those walls. We heard testimony from Ms. Gonzalez that the bullets were very close to her and that the situation could have been deadly very quickly. She's fortunate that she only had bullet fragments in her legs. The defendant's also charged with discharge of a firearm at a building. The first is that the defendant discharged a firearm. Again, from the investigation, the photo lineup, the same clothes from both incidents, the ring camera footage, eyewitnesses. This is how we know that it was the defendant, Keyshawn Foreman, who did discharge this firearm. The second element is that he did so intentionally. 8 bullet holes into the house is intentional. The third element is that he discharged the firearm at a building that had reason to believe was either a dwelling or a potentially occupied structure. We have testimony from Mr. Williams that Mr. Foreman was there earlier that day. He knew it was a house. He knew children resided there. He knew Mr. Williams resided there, and he knew Ms. Gonzalez resided there. And he even told Mr. Williams himself, "I'll be back." Additionally, there's 2 counts of felony firearm. So first, we have to prove that the defendant did commit the crime of assault with intent to murder, as well as discharge of a firearm at a building, and that at the time that he committed those crimes, he did knowingly carry or possess a firearm. So I think that is pretty standard. If the court believes we have met the elements of the other 2 charges, that those would go along pretty smoothly. Additionally, through the testimony of all our 5 witnesses, we've got location, ID, venue, and date here, of course, of July 4th. And the people would just remind the court that this is a probable cause standard and that any question of fact should be left for the jury, and we would request bind over on all 4 charges. Thank you.
Thank you. The response, Mr. Freeman.
Yes, Your Honor, thank you. I would preface my intended remarks by indicating to this court, for purposes of this hearing, that whether a firearm was used is not in dispute. Whether someone shot at the house in question is not in dispute. The day and the time and so forth, that's not in dispute. It is the position of the defense that the people are required to give this court at least some evidence to suggest by a probable cause standard that it was this defendant, Mr. Foreman, who presumably drove that vehicle, opened the back, took out a firearm and shot at the house. I think that there is more evidence here, probably beyond a reasonable doubt, that Mr. Foreman was the person who was in the driveway in the afternoon. And they presented a photo lineup to Mr. Williams, and he said, "Yep, that's the guy that was here this afternoon." Okay. I don't know that that gets us too much further down the road. And apparently, there was a photo array put together as with respect to the person that witness referred to as Empress, and Mr. Williams, at least to some degree, indicated her photograph too. But again, having nothing to do with the charges against my client. And so struggling to try to put Mr. Foreman as the shooter, the government's theory of this case is not quite there. I don't see any evidence here that there was a deliberate effort made to try to identify the vehicle from the 4th of July at 10 o'clock at night. I was hoping we'd hear something about, well, you know, based on the this particular street and the adjoining network of streets, we checked the security camera at X, intersection and Y intersection, and lo and behold, here's this white,
vehicle going through 10 minutes later after the shots were reported to 911. I didn't hear anything that connected the car to my client or even connected a specific car to the 10 o'clock shooting. And in light of this, I would very gently offer to remind the court that Mr. Foreman here, my client, has been incarcerated since the date of his arrest. Okay. And I think it reasonable to believe that the law enforcement community generally, and certainly the prosecuting attorney's office specifically, were aware of or should have been aware of the fact that Mr. Foreman was lodged. And we all know that if someone is held in custody, the first priority is to attempt a corporeal lineup at the jail, try to find 5 other people who are about the same age, height, weight, and so forth. As a practicing attorney in this community, I know that far too often the jail staff are unable to come up with 5 others that are similar enough to pass as to whether the photo array, or excuse me, the corporeal lineup is reliable. And so I know that from time to time, lawyers consent to a photo array just simply because there aren't enough folks in the jail to compare. But there's no evidence before this court that any witness was shown a photo array that included my client and was asked whether this is the person that shot at the house. We don't have that. And I attempted to put a formal pleading together. I'm sorry, all I have are some notes, but the court will recall that the only exhibit offered by the people with respect to any video evidence had to do with their exhibit 1, and that was from the camera of Mr. Williams. And the court saw it, I saw it, the prosecutor saw it. There's no way anyone could have identified a person certain from that. Given the distance away and it was nighttime, and I don't think there was ever a clear shot of the face of that person. And it's interesting to me because when Mr. Williams was interviewed shortly after the shooting occurred, he did not identify anyone. He described the person he saw as a black male wearing a white shirt. And I would just note, for the purposes of preserving this record and possible appellate review, that both the witness, Mr. Davis, as well as my client, Mr. Foreman, are both African-American or black males in terms of trying to identify one. So the situation I find myself in now as a public defender and as the attorney for Mr. Foreman is to, again, gently make the suggestion to this court that Mr. Davis did not identify anyone when he was interviewed by investigating officers immediately following the shooting. But he did give a very modest, bare bones description, black male with a white shirt. Okay, not too helpful. No further descriptive details were given by Davis to law enforcement. And that was shortly after the shooting. Mr. Davis testified that it was sometime after he reviewed video footage from his neighbor's video footage, that he claimed he was able to identify a face. And I'm paraphrasing, of course, but he told us essentially that he recognized the face, and that I've seen that face. And he said, it's from the local convenience store somewhere. I've seen this fellow in there. And he associated the video footage from someone else's security camera as someone that he had remembered seeing in the local convenience store. Didn't know Mr. Foreman's name, didn't know where he lived, didn't know if he owned a car, let alone a white vehicle, didn't know anything else. And so I was hoping that we might see some of the same video footage from the neighbors that Mr. Davis had relied on, but we don't have that. And again, he just indicated that he recognized this individual, and I'd even stipulate that he may have recognized him from having seen him at the local convenience store. Okay. It still doesn't put 2 and 2 to equal 4. We're still coming up with 2 and 2 equals 3. And it's curious that no attempt to present Mr. Davis for a corporeal lineup was made by law enforcement or the people with the understanding that he was in custody. And what's significant about that is this case, judge, of course, will rise or fall as to whether the people can successfully convince 12 people that beyond a reasonable doubt, it was my client, Mr. Foreman, who was the person driving the car that night, opened the back, grabbed the rifle, and started shooting at that house. And I just don't think that they've completed that task. We know if he's in custody, he's entitled to a lineup, particularly if identification is going to be a key element of the pending prosecution. And I would respectfully suggest to this court that it is not only an issue, it is the singular issue in this case. My client's fate will rise or fall on whether the people can satisfactorily demonstrate that the identity of him as the shooter. I know that the courts in Michigan, and I'm not citing a specific one, I didn't get quite that far, but I'm hoping that the court would and counsel would both agree that when we're talking about identification, you've got a couple of different kinds. You've got the kind of identification that happens before a court proceeding. That would be the corporeal lineup or the photo arrays. And if those procedures are followed correctly, then the general rule is the witness may make the identification in court. On the other hand, if the presentation of photographs or otherwise is suggestive, then it's oftentimes not allowed as evidence. A jury doesn't hear that in-court identification from that witness. We're also talking about, I just had to put this on the record, Judge. I hope you understand. I know the hour is late. But when a witness identifies a defendant for the first time in court and there was no pretrial identification procedure arranged by the state, which includes, of course, the prosecution and law enforcement. And I would suggest that that is the case here because the only thing presented was a photo array to Mr. Williams with respect to who was in your driveway that afternoon. All right, I'll stipulate. He identified Mr. Foreman as the person in his driveway that afternoon. Okay. And we're talking about something that happened, what, 6, 7, 8, 9 hours later at 10 o'clock at night. So the court in Michigan, the court are required to consider the reliability factors as to whether any pretrial identification was tainted. Given that there were no formal pretrial attempts to identify Mr. Foreman, this court now must look at the totality of the circumstances to see whether this court should accept the testimony of Mr. Davis as having reliably identified Mr. Foreman as the person he saw fire a rifle. And the courts have told us that in addition to using the totality of the circumstances test to determine reliability, the idea is whether the identification has an independent basis sufficient to allow a court to rule as to whether a first time in court identification is
or is not a reliable identification. And we've seen these before. There's a non-exhaustive list. Our Court of Appeals has told us in published opinions that a reviewing court should look at what was the prior relationship between the witness and the defendant? And the only thing we've got here from Mr. Davis is, I saw the guy in the convenience store from time to time. The length of time between the offense and the disputed identification. My client has been in jail, I think, since October 6th or something. And Mr. Davis, what was it, 6 weeks or so before he was able to identify him in court, or yes, at this first half of this hearing. Accuracy of discrepancies. And again, there weren't any prior attempts to identify. So the court should look to how well the witness's initial description of the defendant matches the defendant's actual description. Black male with a white shirt. That's all we have. Black male with a white shirt. And this court should also see whether the initial description made by a witness matches the defendant's actual description, including any unique or unusual features. And I suppose that's an endless list of possibilities. Wore eyeglasses or didn't, or had a beard or didn't, but we don't have any of that. Mr. Davis did not give the law enforcement any other information that would, in my judgment, considered to be unique or unusual, that we could then look. Oftentimes it has to do with a tattoo, and then we look it back and say, yeah, this person has a tattoo right there. There were no previous proper identifications, so there was no prior improper identifications. And given that there weren't any prior to court, then of course, Mr. Davis did not identify someone else at the lineup and then my client in court. So what we've got here, the last factor that the court suggests this court consider is the level of certainty. The witnesses demonstrated certainty at the time of the identification. I'll stipulate, I was sitting right here and I know that Mr. Davis was adamant. He was excited. He looked at my client and pointed at him, and he was just absolutely certain. But the problem with that is that that assumes that there's a correlation between certainty and accuracy. And this court, I think, has to look at this objectively. And what information was Mr. Davis relying on in order for him to make this first time in court identification? And why weren't any other means of identification employed prior to the first court appearance identification? So I think we need to be careful about certainty. Oh, he was sure. He pointed right at him. He said, yeah, well, that really doesn't have a whole lot to do with accuracy. So I'm asking this court now, I know this isn't a trial, but any evidence considered by this court has to be legally admissible evidence. And I believe that the due process portions of the US and the Michigan constitutions require the defendant who is in custody, and when it's going to be identification is the key issue in a case, he's entitled to a lineup. Now, if his lawyer says, well, okay, they've only got 2 other people at the jail that are similar enough, let's go ahead and do the photo lineup. Okay, that's fine. But there wasn't any evidence before this court that there were any efforts to ask any witness to identify my client prior to our preliminary examination hearing, and certainly not to identify him as the shooter at 10 o'clock at night. So a court, lastly, Judge, I'm going to indicate a court weighs these factors against the corrupting effect of any suggestive identification procedure. And I would argue that the corrupting effect in this case that led to a suggestive identification was the fact that Mr. Foreman was sitting right next to me at the defense table.
in jail garb. It's absolutely reasonable to at least appreciate or understand Mr. Davis. You know, he wants to be helpful, he wants to be a good witness, and he wants to help. And he points at the person who was sitting next to the defense attorney. I just don't see that as sufficiently reliable. And that's the key word, Judge. Was it reliable? I believe that there was a violation of my client's constitutional rights for him to be prosecuted in accordance with due process. They should have had a pre-trial identification procedure of some kind, and that simply didn't happen. And the identification made by Mr. Davis under the facts and circumstances as he presented them, his testimony, it's not reliable. Where's the video footage from the neighbors? We don't have it. We have no idea what he looked at or how he came up with this. He never notified, apparently, law enforcement or the prosecutor's office that, hey, you know, since July 4th, I've had a chance to do this and that and something else. And this has occurred to me, nothing like that. He took the stand, and probably, I know that I did not anticipate he was going to make an in-court identification. I suspect, although I don't know, that counsel didn't really expect it either, but it happened. It happened. And I don't believe that the testimony offered by our detective Bending is sufficient to compensate for that. If Mr. Williams can't identify, if Mr. Davis's identification is not reliable, I believe that the detective's investigation it doesn't connect the dots. All kinds of evidence that he was there, let's just say 2 o'clock in the afternoon. Okay, that has absolutely nothing to do with the shooting at 10 o'clock at night. This is not a situation where I'm talking about circumstantial evidence where someone could rationally or reasonably make certain inferences. There just isn't enough here. And lastly, as I'm sitting down, I always like to say I'm gently reminding the court that our appellate courts have said time and time again that one of the objectives of preliminary examination is to weed out those cases that ought not go forward. If the government wants to continue their investigation, if they want to explore some other possibilities to collect evidence that would be in support of identifying my client as the shooter, terrific. But I object to the motion for bindover, and I believe that this entire case should be dismissed if that would please the court. Thank you.
All right, thank you. Ms. Fortuna Gill, response and response to the response, and then or we can wait, okay? Because I don't have clearly in my notes what happened last time. Okay.
Okay.
And I know your motion, but I also want to see the transcript. Okay.
Sure.
From November 14th, because it's been 3 weeks, and so I will allow the parties to entertain a motion after they see the transcript. Also, it's been so November 14th was the initial when we started. We saw 4 witnesses on that day, and we have the detective today's date. I'd like to have all the transcripts, both in order, because as I see it, some of the identification is direct and some of it's indirect, or circumstantial or non-circumstantial. And I'd like to see all the transcripts, and the transcript would suffice, since we know exactly what they said before. With that understanding, you can respond, or we can just have a new response after council gets to see the transcripts from the first hearing, which is November 14th.
Your Honor, I would like to make a brief response now while it's fresh in my mind, but I have no objection to looking at the transcripts and us having a bind over.
I'd hold it under advisement, and then I take the bind over motion for bind over after I see the transcripts from November 14th and December 5th.
That seems reasonable to
Okay,
me,
yeah.
but if I could briefly address. the board.
Absolutely. And then I will give counsel the opportunity after they read the transcripts to make the further arguments.
Thank you, Your Honor. I just want to bring it to the court's attention. I know Mr. Freeman had said that the people cannot prove beyond a reasonable doubt today that it was Mr. Foreman who was the shooter on July 4th. However, that's not our standard today. Our standard is a probable cause standard. And this is a situation where there's smoke, there's fire. I mean, we have the same clothing from the afternoon confrontation, which there is no dispute that Mr. Foreman had an afternoon confrontation with Mr. Williams at the exact house that was shot up. We know that he's wearing the same clothing during that confrontation as the shooter of the video. We additionally know that it's the same vehicle of the afternoon confrontation as the 10 p.m. shooting. And we know that it's that same license plate that was seen in South Carolina where Mr. Foreman was picked up for this. So it's more than just Mr. Davis's on the spot identification of Mr. Foreman. There's lots of dots here and they do all connect. We have Mr. Foreman, like I said, it's not disputed. He agrees that he went and confronted Mr. Williams. He told Mr. Williams, quote, "I'll be back," in an angry tone. That same day in the driveway, driving the exact same car we see later on security camera footage. So I just want to bring up to the court that it does seem that it's a where there's smoke, there's fire situation to me. It's more than just Mr. Davis's on the spot identification that we did have. With that being said, I'll reserve the rest of my arguments for when we have all the transcripts, and I'll motion for bind over that.
All right, and then so the real question is, when can they do the transcripts? And I'm not asking for anything. I'm not asking. You'll let me know. What's the time frame we're looking at?
Well, it's kind of hard for me to say right now with the holidays and filling it. So I will do whatever I can to get it done as soon as I can.
But give us a realistic date.
A realistic date.
Would be after the holidays, I would assume. Yeah. So it'd be so I would think late January, if not mid to late January.
Oh,
I would think at least 30 days, and then we got the holidays right in that.
30 days would be nice.
Okay.
But if you needed it before, I would do everything.
Well, let's say at least 30 days, and then if we get it before, but that's my understanding is serious allegations. I want to make sure to read the entire transcript from November 14th and December 5th before I make a decision. This has to do with a direct identification and somewhat a circumstantial identification. I think that is the key issue here, because we have video of somebody shooting at the house, and we have the person who was in the house shooting, so we have to identify the person. So we'll set it at, I would think, somewhere around the last week of January. And I'm not here.
So it's either the 3rd or 6th of January.
Let's try.
Coach, are you gonna be here?
I don't know.
I know we're here on the 5th of January, I think.
No, I mean.
Yeah, I'm having surgery in January. And so you guys might be here, but I might be here, I might not be here, and I've got to read the transcripts. So I would think that and I've got an old calendar here because I don't have the 2026 calendar.
Yeah.
What is the second week of February look like? And that can be the 6th or the 7th, since we're just coming back on a.
Yeah, I just wanted to indicate, if I may please, in terms of the scheduling, I'm supposed to be going the first 2 weeks of February.
That's not helpful.
Well,
but that's
this is early enough that I can tweak it.
Right.
Well,
yeah, we have the same problem. It's just scheduling. I think
There's the 12th or the third, I mean, I think you're back on the 8th.
I'm back on the 8th.
Friday, the 13th is a prelim day.
What is, what's the first Thursday? So the 8th is the first week of February. Is that?
Yes.
All
No,
right.
no, it's the second.
The second, that's the Monday. What's
Monday's the 9th.
Monday's the 9th. I'm back that night.
Maybe you're back. You're out through the 6th, so yeah, you're back on
9th. What is the first Thursday, Friday after that?
the 12th and the 13th.
Then, and is it,
The 12th is a probable cause.
let's hold it on a
conference in the
PCC
morning.
day,
Okay,
since
like-
we're not gonna take any testimony.
Like 10 o'clock maybe, because you have a probable cause conferences up until 9:30.
All right. So we'll be back here with the motion for bind over under advisement on February 10th.
Not 12,
I'm sorry, February 12th at
10 a.m.
10 a.m. And therefore, I know that I'll read the transcripts and I'll come to the decision. And also that'll give the attorneys time to read the transcripts and make a determination. And then Mr. Freeman, you can adjust the schedule as you see necessary, but it's the February 12th at 10 a.m. That is, and the 13th, I think, would also work. We're just trying to make it on the PCC day, but the prelim would also work that day. So the 12th or 13th would work, I would think. Yeah, so if there's a preferred day, but we're setting it on the 12th or the 13th would work also. We'll be back on that date on February 12th at 10 o'clock. Is that correct?
Yeah.
All right. And then that should allow some time for the transcripts to be done and then more than enough time to review the transcripts for argument. Anything else? So this is taken under advisement to February 12th at 10 a.m. Anything else for the record, Ms. Fortuna Gill?
Not for the people, Your Honor.
Mr. Freeman?
Just, if I may, please.
Yes.
Of course, we didn't anticipate, parties didn't anticipate.
Right. That's just the nature of the case,
Yeah,
coming out
yeah.
with facts.
And, but on the other hand, in that light, it's certainly not Mr. Foreman's doing. Even though he is charged the way he is, I still would like to move the court before the court loses jurisdiction of the case to respectfully consider a lesser amount of the bond. I'm not going to ask for a PR bond, but something in the order of, 2,500, or excuse me, 25,000, 10%, or and with the GPS tether, house arrest, whatever other criteria are sufficient to assure everybody that he's not posing a danger to anybody during the pendency of his case. If the court wished to take that motion under advisement until we come back in February.
I'll listen to arguments because we have the date now. I'll listen to any response from the prosecutor's office. I do understand that Mr. Foreman was picked up out of state. Is that correct?
That is correct.
He was
Your Honor.
correct. He was picked up in South Carolina.
I don't have any information to that regard, but I certainly am not going to challenge the information offered by the prosecution. Thank you.
All right, response.
Your Honor, the people would strongly oppose any reduction or change in bond at this point. Obviously, we all see the severity of the crimes that Mr. Foreman is accused of. But additionally, I mean, I'm looking at the criminal history. It's filled with a lot of crimes involving firearms, Your Honor. I think that it would be a disservice to the community to reduce bond at this point. I have a CCW from 2024 and also currently in circuit court, pending in circuit court, has already been found over as a home invasion, felon, and then a felony firearm, possession of a firearm by a prohibited person, felonious assault, another felony firearm. Your Honor, I just think it's too risky.
Those are all pending cases. Is that
Yes,
correct?
those are pending. Those are not convictions.
Based on the life offense and the prior felony of CCW, I'm going to deny the motion to reduce bond. it's also it's also become that there's a flight risk element here because the defendant was found out of state and picked up out of state on pending matters in circuit court. So I'm going to deny the motion to reduce bond, and we will be back here on February 10th. So motion for bind over will be February 12th. February 12th at 10 o'clock.
Yep.
At 10 o'clock. All right. All right. So we'll be back here. Motion is set in abeyance so we get issued transcripts from November 14th and December 5th, and we'll come back here, reconvene on February 12th at 10 o'clock. Anything else for the record in 2502-321, Ms. Fortuna Gill?
No, thank you, Your
Mr.
Honor.
Freeman.
Nothing further. Thank
All
you.
right, thank you. You're all set. Thank you for your appearance today.
Okay, yeah, okay. I got a little thing that have you signed, but yeah, sure. I told you last time, I told him today, I said, I gotta retouch.
It's all right. You've got a role to play just like everybody else.
It's getting more and more difficult to do it with a straight face.
Yeah, absolutely.
Yes, I do. Thank you very much.
All right, let's get the transcripts. So I'll look at it, then we'll go from there.
Have a good weekend, Your
You
Honor.
too. I've got some interviews this
What?
afternoon.
I said that's right. We're done. Yeah, we're done finally. Long morning. You guys don't have anything in the afternoon, right? Okay,
I was
good.
supposed to tell him.
No, we're interviewing for Tammy's position.
Oh, okay.
Because Tammy doesn't want
I
it.
like Tammy.
I did retire and then.
Brought you
So
back.
much fun, please.
Yeah,
Thank
Wendy
you, Mr. Freeman.
resigned or retired or whatever, and then they brought me back to fill in until they could get a new hire.
I'll be right back and I will clean up my mess.
We're just
Oh,
doing,
you're fine.
the 14th, right?
Well, I take it he wants, do you want today too?
No, I don't. I didn't understand. I
Yeah.
was just trying to do a shortcut here. I don't need the arguments at the end, and I don't need,
Oh, I would love you, no, not to have to type the arguments
I mean, I
of
don't
today.
need, yeah.
Do you just want witness testimony only? The
From the
14th?
14th.
I'll see what he wants, but I don't think he needs the argument either, even if I just did witness testimony from today. That would be a lot less.
Yeah, it's a waste of time to do.
Yeah, and it's so hard, you know.
It's just lawyers talking for
It
heaven's
is-
sakes.
It is, and it's so hard to type because you don't, you're on the fly and you're arguing cases or, you're arguing the case and everything doesn't flow as nicely as the question answers do, you know what I mean? And
I
so
do.
sometimes it's hard to punctuate or how, because they're just run-on sentences or you'll go in a different direction or same with the judge's ruling. I'm like, why do I have to type
I've never been a court recorder. I've never done a transcript, but
They're so
I
hard when
I
it
can
comes
actually
like that.
hear what you're saying. Yep.
Yeah,
And just like
Yeah.
if I put a pleading together
yeah.
and I cite cases, I take a separate piece of paper and I put all the cases
You
and
give it to the court
and give them
recorder?
to the
Oh,
court
you're the
recorder. So
best.
nobody's, now, how do you spell that? It's Wakinski or is it?
I know.
Here, it's right here. Those,
I love that.
yeah.
I love that. I wish
Yeah.
everybody did that because
Well,
sometimes.
anyway, retired or not, it's good to see you.
Well, thank you. It was good to see you too.
All righty.
I think I'm gonna stick around for a little bit, through January maybe.
Well, now I have to go make someone else's life miserable. I've done enough damage here, so I'm gonna go
Well,
bother
have
somebody,
fun.
go bother somebody else. I didn't have to run on for so long. Had I known we were gonna, he was gonna take it under advisement and come back